I would like to invite Ms. Shabnam Mayat, steering committee member of Global Sumud Flotilla and barrister at the Johannesburg Bar, to address the audience on behalf of the Global Sumud Flotilla initiative. I would like to invite and barrister at the Johannesburg Bar to address the audience on behalf of the Global Sumud Flotilla initiative.
Good morning, esteemed colleagues, our special guests, distinguished members of the legal fraternity, activists and friends. On behalf of the Global Sumud Flotilla and the Legal Coordination, the Worldwide Lawyers Association, and Muğla Sıtkı Koçman University, I would like to welcome you. I would like to warmly welcome you to this session on civilian resistance against the genocide. I represent one of the co-leads of the legal coordination. We are made up of over 100 lawyers to more than 30 countries. And for us, it is imperative that the law is utilized as a weapon of solidarity and accountability. A manner in which to hold complicit actors accountable across all jurisdictions and in all creative legal ways. We want the legal actions that we take to serve Palestinian liberation and to thereby create precedents which will serve the liberation of oppressed people everywhere. Along with their mission to break the siege in the event of interception, our participants become both witnesses and survivors of the crimes of a genocidal regime. This places them in a very unique position to take forward cases against Israel. It is in the spirit that I invite all of you today to share your ideas, to deliberate with us, to share your experiences, and to begin charting a future plan that we may genocidal regime. I want to thank you once again for being here, and I look forward to sharing the day with you.
Thank you so much, Ms. Mayat. And now, I'd like to kindly invite the President of the Worldwide Lawyers Association, Attorney Enes Kafadar, to the stage for his opening remarks.
Sayın Başsavcım, değerli protokol, kıymetli hazurun, saygıdeğer basın mensupları, filomuzun değerli yolcuları, kıymetli meslektaşlarım. Yeryüzü Avukatları Derneği adına sizleri saygıyla selamlıyorum. Bugün bu konferansta yalnızca akademik ve teorik bir tartışma yürütmek için değil, hukukun, adaletin ve vicdanın omuzlarımıza yüklediği tarihi bir sorumluluğun gereğini yapmak üzere bir aradayız. İçinden geçtiğimiz belirsizlikler çağı, küresel sistemin ve kurallara dayalı düzenin ciddi bir kriz yaşadığı dönemdir. Gazze'de aylardır tanık olduğumuz tablo, sadece bir halkın maruz kaldığı ağır bir kıyım değil, aynı zamanda İkinci Dünya Savaşı'ndan bu yana inşa edilen ve evrensel olduğu iddia edilen uluslararası hukuk sisteminin çöküşünün ilanıdır. Biliyoruz ki uluslararası hukuk, 10 yıllar boyunca batılı hegemonik güçlerin kendi çıkarlarını koruduğu ve küresel hiyerarşiyi tahkim ettiği bir araç olarak kullanıldı. Kuralları onlar koydu, istisnaları kendi lehlerine onlar işletti. Ancak yeryüzü avukatları olarak biz sistemin bu ikiyüzlülüğüne bakıp uluslararası hukuku reddetmiyoruz. Tam aksine hukuku bir tahakküm aracı olmaktan çıkartıp asıl işlevine, yani mazlumun ve adaletin güvencesini korumaya, geri döndürmeye hedefliyoruz. Bu mekanizmaları onları kendi tekeline alanların elinden kurtarmak zorundayız. Değerli konuklar, küresel sumut filosu işte tam bu yeni hukuk vizyonumuzun sahadaki somut karşılığı ve yansımasıdır. Burada hepimizin yüzleşmesi gereken temel bir mesele var. Bu haklı ve meşru eylemin küresel kamuoyunda nasıl yankı bulacağı ve uluslararası sistemde nasıl korunacağı. Karşımızda sadece kuralları ihlal eden bir yapı değil, işlediği soykırımı dünyanın gözü önünde meşrulaştırmaya çalışan, uluslararası mahkemeleri hiçe sayan, kibrinden kör olmuş haydut bir devlet aklı var. Bu akıl, sivil ve barışçıl filomuzu uluslararası hukuka bir tehdit, ablukayı kırma irademizi ise bir provokasyon olarak yaftalamaya çalışıyor ve çalışacaktır. Bizim mücadelemiz bu ters yüz edilmiş algıyı kırmaktır. Açıkça ifade etmek gerekirse, uluslararası suları militarize ederek bir halka açlığa mahkum eden bu terör aygıtı bir şekilde engellenmelidir. Meşru olan Birleşmiş Milletler Güvenlik Konseyi'nin felç edildiği ve devletlerin acize düştüğü bir denklemde inisiyatif alarak hukuku işletmeye çalışan sivil iradedir. Yani bu filonun ta kendisidir. Sumut filosu hukuku ihlal etmiyor. Aksine soykırımı önleme yükümlülüğünü yerine getirmeyen devletlerin bıraktığı boşluğu doldurarak evrensel hukukun gereğini yerine getiriyor. Biz filonun meşruiyetini tartışmaya açanlara karşı savunmada kalmayacağız. Haklılığımızı tavizsiz ve sağlam bir hukuki zeminde savunacağız. Şunu da çok iyi biliyoruz. Uluslararası hukuk sadece ihlaller yaşandıktan sonra failleri yargılayan pasif bir cezalandırma mekanizması değildir. Aksine diplomasi masasını kuran, devletler arası ilişkilerin seyrini belirleyen ve siyasi gündemi tayin eden son derece etkili bir güçtür. Yakın zamanda haksız yere alıkonulan aktivist dostlarımız Tiago ve Seyf'in serbest bırakılmasını bekliyoruz. Uluslararası hukukun bu diplomasideki gücü ve kudreti inşallah bize yakın zamanda bunu sağlayacak. Kıymetli meslektaşlarım, değerli konuklarım, WOLAS olarak durduğumuz yer son derece net. Gazze halkının o sarsılmaz sumut ruhu, haklı bir direnişin ne demek olduğunu tüm dünyaya gösterdi. Hukukçular olarak bizlere düşen görev ise bu meşru direnişin uluslararası alandaki hukuki zeminini etkili bir şekilde inşa etmektir. Bu konferansın sadece teorik tespitler yapılan bir konferans değil, somut hukuki üreticilerin üretildiği verimli bir çalışma olacağına inanıyorum. Haklı yürüyüşümüzün o gemiler Gazze limanına demirleyene ve adalet tesis edilene kadar kararlılıkla sürdüreceğimizi ifade ediyorum. Kıymetli katılımcılar, son olarak bu misyon gerçekten çok zorlu bir misyon. Devletimizin, Türkiye Cumhuriyeti Devleti'nin adli ve idari kurumlarının kolaylaştırıcı etkisi olmasaydı bu işler çok zor şekilde yürütülecekti. O yüzden ben huzurlarınızda tekrar özellikle adli makamlarımıza, adalet mekanizmamızın mensuplarına huzurlarınızda bir kez daha teşekkür etmek istiyorum. İdari makamlarımıza yaptıkları kolaylaştırıcılıklardan dolayı teşekkür etmek istiyorum. Muğla Sıtkı Koçman Üniversitemize, rektörlüğümüze, sayın rektörümüze huzurlarınızda bir kez daha bize böyle bir imkan sağladığı için teşekkür etmek istiyorum. Yine Global Sumud Filosu'nun Türkiye delegasyonu, Sayın Ayşegül Hanım, Sayın Ayçin Hanım, Hüseyin Bey gerçekten çok emek sarf ettiler. Bu süreci en iyi şekilde yürütmek adına. Ben onlara da huzurlarınızda bir kez daha teşekkür ediyorum ve bu şekilde sözlerimi noktalıyorum. Teşekkürler.
Thank you, Mr. Kapadar, for your opening remarks. And now, I would like to kindly invite the Chief Prosecutor, His Excellency Oğuzhan Dönmez, to the stage to deliver their opening remarks. Oğuzhan Dönmez to the stage
Sayın Birleşmiş Milletler Özel Raportörü, kıymetli protokol, değerli hukukçular, misafirler ve kıymetli basın mensupları. Sizleri adaletin ve hukukun evrensel değerlerini savunmak adına bir araya geldiğimiz bu anlamlı platformda saygıyla selamlıyorum. Muğla'mıza hoş geldiniz. Bugün burada Gazze'de yaşanan ve insanlık vicdanını derinden yaralayan trajediyi sadece siyasi değil, uluslararası hukukun ve insan haklarının temel ilkeleri ışığında değerlendirmek üzere toplandık. Bir hukuk adamı olarak ifade etmeliyim ki, soykırım, insanlığın ortak mirasına karşı işlenmiş en ağır suçtur ve hiçbir gerekçe bu suçu meşrulaştıramaz. İnsan hakları sadece metinlerde kalan birer vaat değil, her bireyin her şart altında sahip olduğu dokunulmaz bir kalkandır. Hukuk suskun kalmak için değil, haksızlığa karşı durmak ve hesap verebilirliği tesis etmek için vardır. Bu konferans, sivil inisiyatiflerin hukuk zemininde nasıl bir direnişe dönüşebileceğini göstermesi bakımından tarihi bir öneme sahiptir. Adaletin coğrafyası yoktur. Dünyanın neresinde olursa olsun soykırıma karşı durmak bir hukukçu için sadece mesleki değil, insani bir zorunluluktur. Bu kıymetli organizasyona emek veren Yeryüzü Avukatları Derneği'ne ve tüm katılımcılara teşekkür ediyor. Konferansın adaletin tecellisine giden yolda güçlü bir ses olmasını diliyorum. Hukukun üstünlüğüne olan sarsılmaz inancımla hepinizi saygıyla selamlıyorum.
Thank you, Mr. Yılmaz. With this, we conclude the opening protocol session of our conference. We once again thank all distinguished participants and guests for their presence and contributions. Now we will proceed to the keynote address by Muhsin El-Attar, professor at Xi'an Jiatong Liverpool University. Please join me in welcoming him to the stage.
So the remarks that I prepared were obviously intended for a different context. And I will ask for your patience as I work through these remarks and I try to tailor them for the audience that is before me. Now what I intended on to beginning with was the audience itself. And I wanted to begin with the people in this room, the people who are about to set sail across the high seas, and we're going to confront the Israeli blockade. And I was going to point out that they were doing so at great personal risk, as we know that Israel kills activists who engage specifically in these types of actions and many others, and they did so some years ago. Of course, we also know that Israel has since killed tens of thousands more, and largely just for being alive. And yet 16 years later, after that very first mission, the blockade still holds. And perhaps the only thing that has changed has been the intensification of Israeli impunity, the intensification of that brutality that Israel engages in. And so today, Gaza is no longer just a space that is under siege. It has become an actual killing field, a cemetery, a graveyard for children, as the UN Secretary General said. Now, at the outset, I don't mind admitting to you that I have not always supported this particular action. I've not opposed it, but I haven't supported it either. And I'll be honest with you and say that I still remain uncertain. But if there's one thing that I do know, it's that uncertainty about tactics should not be confused with uncertainty about principles or about duties. And when Israel commits a genocide and much of Europe looks the other way, when Israel commits a genocide and institutional channels prove ineffective, prove timid, prove fearful, when Israel commits a genocide, we can no longer look for the perfect act of resistance. We have to grab what is in front of us. We have to mix up the tactics. And we challenge them on every front so as to ensure that the cost of their barbarism is self-defeating. And that is what I am thinking through with you today. What does resistance look like when the very international legal order that we expect to draw upon to support the Palestinians is also the same order that is enabling their domination, their extermination? And so I'd like to say a couple of words then about the high seas. I'd like to say a couple of words about Zionism, and then I'd like to conclude with a few words about the flotilla and the implications of the action that they are undertaking now. And what are the high seas? And the high seas we see as a place of freedom, but it's important to recognize that the high seas, or at least the law surrounding the high seas, was always a place of violence. Hugo Grotius, the scholar who shaped the law of the seas, many of us recognize and know that he worked for the Dutch East India Company. And this was at the height of Dutch imperialism, Dutch colonialism, and to him, the waterways were merely a space to facilitate the movement of goods, of capital, and of military. The Dutch at the time were trying to seize the trade routes from the Portuguese. They wanted to transport, they wanted to enslave and transport people via these waterways. They wanted to make war. And so he developed the law of the seas in a way that would enable Dutch imperialism and ultimately Dutch colonialism. And that system of international law ended up serving European imperialism quite well. The sea connected the colonies to the metropole to facilitate then the acts of plunder that they were engaged in. The seas facilitated the carrying of soldiers, of militias that could subdue indigenous peoples in their lands. The seas were used to transport people who had been transformed into commodities, into chattel. In other words, domination of the high seas was very much at the heart of colonial domination. And Israel's blockade of Gaza is the latest expression of that violence. Now, Israel's blockade, feels remarkable to say this, is nearing its 20th anniversary. Israel controls what enters Gaza by land, by air, and of course, by the sea. Israel controls what the Palestinians eat. It controls what medicines they have access to, which medicines they do not. It controls who can visit them, when they can leave, when they can return. It even controls what materials they can use to rebuild their homes after they've been demolished by the Israelis. Now, it goes without saying that every aspect of the blockade, every single one, is a violation of the most basic elements of international law. So it is not simply that it is unlawful, it is also morally reprehensible. But what I have to mention today is that the blockade is also a legal strategy. It is designed to produce the very conditions that we see in Gaza today. Overcrowding, despondency, destitution, despair. And then Israel uses each and every one of those conditions as a way to justify escalating the violence it carries out against them. And perhaps most of all, what the blockade does, and this I say is a legal strategy, is that it forces the commingling of combatants and civilians. They live together, side by side. And because of the density of Gaza, the consequence is that no clean strike is ever possible. And so the hospital is always going to be a command center. The school is always going to be an ammunition depot. The refugee camp is always going to be a training ground for operatives. And in this way, what Israel has been very much to perfect the practice of lawfare. It uses law as a weapon of war. Israel invests heavily in lawyers, heavily in legal education, heavily in legal scholarship, and it seeks to produce different forms of juridical innovation. I sometimes think to myself, they're still practicing a kind of ijtihad in the way that they try to develop new forms of international humanitarian law. They target proportionality, they target distinction, and they target necessity. The three pillars that are used to create a type of ambiguity to ultimately justify the violence that they're carrying out. So, what is a proportionate response to an assassination? Is it to drop a 1-ton bomb on a building? Well, that becomes a question for us to deliberate. How do you distinguish between a civilian and a combatant? If a combatant is walking down the street with their child, are they a civilian or are they a combatant? Legal articles are written about that. What do you do how do you determine when a civilian space, a civilian infrastructure becomes a legitimate target? These are the questions that Israeli lawyers, Israeli legal academics are spreading across legal journals, across legal blogs, and bringing before the International Court of Justice. So we've heard about human shields, we've heard about command centers, and what this framing does is to disconnect the killing of Palestinians from the structure that Israel has created to facilitate the killing. So that is what I have to be clear about when it comes to the blockade. The blockade, more than a military strategy, it's a failed military strategy, but it is a most effective legal one because it enables a kind of sanitization of European guilt. And an easy example is every time we read about a bombing, whether it is in Gaza, or it is in Lebanon, or it is in Syria, we are told that the Israelis issued a warning. They called for them to leave their homes, or to face them because they are in grave danger if they stay. And the media has been reporting this for years, as if it has some kind of legal or moral validity. And this is merely a tactic to ultimately sanitize European guilt, and of course Israeli guilt as well. When civilians are killed, they say, but why didn't they listen? They gave them the warnings. They gave them advance notice. They told them. Now, in the same way that the blockade must be understood as a legal strategy, we also have to understand that the genocide that Israel has committed is a product of the blockade, meaning the genocide is also a legal strategy. I blockade people into this tiny space, I wall them in, I destroy all of the infrastructure, all the conditions for life, and the population has nowhere to flee. And within that chaos, distinction between civilian and combatant becomes impossible to make. Meaning, I am at liberty to destroy everything because they are all corralled together. And within that chaos, it is a dastardly plan. But it is a dastardly plan that has worked very well. And notice how once the bombing began, how many European leaders came out to say they have a right to defend themselves. That right to defend themselves, according to Keir Starmer, still the Prime Minister of the UK, at least for the next week or so, said, you can deny them water, you can deny them food, you can deny them shelter. That is itself a form of self-defense. Merz, Macron, von der Leyen, the entire elite of European bureaucracy falling in line to defend a genocide and declaring that the genocide itself is a form of self-defense because of Hamas. So the blockade is set up as a way to create that indistinction, that impossibility of distinguishing, and then give him a kind of carte blanche to carry out the killing. This is what I often refer to as the weaponization of legal ambiguity. But more than anything else, it feels very much like the conducting of ethnic cleansing through law. And notice the analyses, the procedural delays, the investigations, all of that is part of the strategy because Israel is capitalizing on the slowness of law to continue not just the extermination, but also the dispossession of the Palestinians. Notice how the line keeps moving, and Gaza keeps getting smaller and smaller and smaller. And perhaps most of all, the Israelis, like many of the Europeans, no longer speak of Gaza as a home. It is now a permanent conflict zone to be managed by a securitized narrative. And I say, and we can talk about this later, that permanent war is necessary to keep Zionism intact. And so I'll take 5 minutes now to conclude on the flotilla. And this is the part that I had very much directed for the activists. And I don't think the flotilla is merely a symbolic act. I don't see it that way at all. The flotilla is repurposing the sea from this site of violence into a site of solidarity and struggle against domination. It is a legal act because we're using the high seas as the law says we can use the high seas. It is a political act because it's conveying to the Palestinians that we're not giving up the struggle. Even after Israel carries out this wanton violence, the activists remain and continue in solidarity. And it's a humanitarian act because it continues to draw attention on the barbarism that is a siege against a civilian population. Now, it's important to underscore that Israel is very comfortable with its hypocrisy. It will claim legal protections for itself that it will in an instant deny to everyone else. That's the nature of an ethno-chauvinist doctrine. It's the nature of an ethno-supremacist outlook that is the basis of Zionism. Israel loves the law, but it hates direct action, because direct action shows it for what it is. And so the activists who turned the sea from a site of violence into a site of Sumud, that is a revolutionary act that disrupts the plan. The flotilla isn't begging for permission to exist. The flotilla is not petitioning the Security Council for help. It's not asking the ICJ to rule on the matter. The activists are not waiting for some kind of body to say that, yes, Palestinian lives matter. We recognize that. They are taking action. Now, Israel has implemented not just an occupation, not just a siege, not just a perpetual war. It hasn't just blurred the distinction between civilian and combatant. It has pursued policies of terror, policies of extermination, ethnic cleansing, and ultimately genocide. It has even attempted a final solution in Gaza that has failed. But it is really quite something that we still describe Israel as a state. It has violated every basic tenet of what it means to be a state, and has transformed itself into a death cult that is very much committed to the annihilation, not simply of a people, but of an entire region. But as I said, its final solution failed. And it failed not because of international law. International law has done nothing to stop the genocide. It failed because of activists. And this is where I return to what I said at the outset about the flotilla. In conditions of genocide, the politics of proliferation are necessary. We proliferate resistance in every way. The legal way, the diplomatic way, the economic, the political, the physical. We keep raising, ratcheting up the costs. So yes, we target institutions. The ICJ, the ICC, use those spaces. Yes, we will use legal channels. But we don't put our faith in international law. I do not know if the flotilla is the right tactic. But what I can say is that during a genocide, we don't have the luxury to debate which is the right or wrong tactic. The resistance, however imperfect, has to be multi-layered, has to be principled, and unfortunately, it has to be high risk. And that is why I look at the flotilla. I look at the flotilla in awe, the courage then that they demonstrate, and how they are taking a space that was conceptualized by a Dutch in-house counsel for an imperial colonial company, taking his ideas about what the sea is meant to be for colonial armies and transforming it into a site of Sumud. And that act alone matters. And so what I say then to the activists is, you sail with the knowledge that what you are doing matters. I pray for your safety, and I pray then for Palestinian liberation. Thank you.
Thank you, Professor, for your enlightening remarks. Now, without further ado, we will proceed with our first session, titled Gaza Blockade, Naval Warfare, and humanitarian access under international law. I would like to invite our esteemed speakers and moderator to this stage. Please welcome Mr. Şebnem Mayet, Mrs. Şebnem Mayet, Mr. Beheshti Aydoğan, Mr. Ali Osman Karaoğlu, Mr. Hüseyin Dişli, and Mr. Badar Al-Naomi, who will join us via video call.
I feel very honored to be able to introduce my colleague in the legal coordination of the GSF, Badar Al-Naomi, and he will be speaking about upholding Sumud through the law and explaining to you the legal strategy that we have been using within the legal coordination in the Sumud team. And he is an independent researcher in law, technology, and political economy. And while Badar is joining us on the screen, I want to invite all of you and those watching online to please come out to the Port of Marmaris and come and speak to the participants, meet them, talk to them, and be part of the proceedings over the next days. Thank you.
First, I'd like to start with a question from Spiva. Can the subaltern speak? Yes, the subaltern can speak in many languages. They speak when they sow the earth. They speak when they stand in front of the bulldozer that is going to tear down their house. They speak when they resist the colonizer. But the question is whether the law listens to the subaltern when they do speak. So this is what we must strive to do, to force the law to listen. They speak when they stand in front of the bulldozer that is going to... Our vision in the GSF legal working group is that we must transform law from being a defensive shield, as in something that only focuses on positivist, formalistic inscription of rights, into a weapon of solidarity and accountability. So we do this by upholding Sumud and centering Palestinian self-determination in the heart of our work. We hold complicit actors accountable across all jurisdictions. We are committed to building an international legal movement where every legal action serves Palestinian liberation, and every witness becomes an agent of accountability, and every case builds towards lasting justice. So, our main objective, the main objective of the GSF, is to break the decades-long illegal siege on the Palestinian people in Gaza. So what does this objective mean for us as a legal community? While the siege is often conceived of as a closed border crossing and military vessels patrolling the shores of Gaza, electrified fences keeping Palestinians in the world's largest open-air prison that has now been transformed into the world's largest death camp. The siege is these things, but it's not only these things. The siege is also a system underpinned by norms. It's a legal regime that facilitates, reinforces, and reproduces the genocide, reproduces the manufactured famine, and destruction of life and environment. The siege is the restriction on the imports of nutritious foods. It is the brutal system of permits that bars Palestinians from travel. It is the legitimation of these crimes under the so-called law of warfare. And it is also the outcome of complicit acceptance of this legal order. This is why breaking the siege cannot be accomplished solely by physically opening a maritime humanitarian corridor. Breaking the siege requires challenging the colonial legal logics that sustain it. So with that being said, how do we actually put this into practice? One of the most important shifts in the work of GSF Legal is a redefinition of the key legal subject of our work, GSF members and mission participants, as agents of accountability. In Arabic, we use the word shahada to mean the act of documenting an event and providing knowledge about it, to create knowledge about it. It's a powerful word that highlights what being present in an event, what sailing to Gaza can achieve. Our agents of accountability use their senses, use their minds, use their bodies, their experiences to make the law listen to the subaltern that it seeks to ignore. Creating knowledge is one of the most essential human actions one can do, and this act connects people from across the world with the besieged people of Palestine. Through this, we prioritize actions that document and expose the role of states and institutions in facilitating the genocide and continued occupation of Palestine. We also organize nationally in the form of national legal teams. We have national legal teams across 30 different countries from all continents in the globe. In each of these countries, these national legal teams undertake legal actions from a strategic litigation perspective, targeting legal actions across a wide variety of forums and institutions, including domestic courts, national human rights bodies, international and regional courts, and UN mechanisms. National legal teams are the beating heart of GSF Legal's work. The impact that can be achieved at the national level cannot be underestimated in such a movement. National human rights bodies, international and regional courts. Another mechanism is an evidence collection mechanism that we work with facilitate both at the international and national levels. So during this mission alone, we have successfully documented nearly 80 witness statements and a large amount of digital evidence of Zionist violations against the flotilla and by extension against the besieged people of Palestine. So far, national legal teams in Italy, Spain and Turkey have already pushed public prosecutors to open criminal investigations into violations and against the flotilla, and like I said, by extension, into the widespread violations committed by occupational forces in Gaza. This is supported, like I said, by an evidence collection mechanism that delivers high-quality evidence across different jurisdictions to promote a variety of legal actions, including urgent provisional measures, criminal complaints, notices to human rights committees, and more. GSF Legal is also an active contributor to the GSF's political strategies and planning through research, legal opinion, and advice provided by our legal research team, national legal teams, our incident reporting team, and specialist advisors who provide valuable reports and advice on a variety of legal subjects and questions. Legal actions and law in general are most impactful when combined with other processes. And so I conclude with a call to action to the audience and to the legal community across the world that if we are committed to executing on a long-term action plan that outlasts the mission itself, then we must also recognize that justice is a sustained struggle rather than a single event. And so we call on the global legal community to join efforts with all people and all parties working towards the liberation of Palestine, to build on opportunities presented by actions like the Global Sumud Flotilla to extract real accountability for crimes against the Palestinian people, and in particular to advocate for sanctions against the occupation and for reparations and an end to the denial of the Palestinian people's right to self-determination. Thank you very much, and Free Palestine.
Thank you very much for that, Madam. And I think one thing that we're really proud of this week, it's one of those rare weeks where we got good news fast, and it showed exactly how the national legal PhD from the University of Warwick, and his research focused on the legal dimensions of institutional actions and responsibility within international organizations. So we have your work. Thank you very much. Yes, of course, thank you. Wherever you're comfortable.
Thank you, Mr. Chair. So, I'm waiting my presentation to be open. I'd like to show some visuals to accompany my presentation. Thank you, Mr. Chair. I think this seems like shut down. May I have what? Okay, distinguished guests. My presentation focuses on two interconnected arguments. First, I will argue that the blockade imposed on Gaza itself, the blockade itself, was a constitution of attempted genocide. Two interconnected. My argument will focus on first an attempted genocide, and then I will discuss how the international community, despite clear obligations upon states, largely failed to prevent this attempted genocide, and it led to the actual genocide that we are experiencing and facing for the last 2 years. So before doing that, I'd like you to pay attention what does Gaza blockade look like. You know, Israel created unlivable conditions even before the blockade itself, you know, starting from the early 1990s, you know, by taking some illegal measures and actions. Then after the, you know, second intifada, Hamas, you know, won the election and Israel didn't like it. So after the serious events and Gaza people somehow put under the siege in a fenced area in an open air prison. So Israel controlled Gaza by land, air, and sea. You know, everywhere Israel's enforcement was due. So that's why this situation, this environment became unlivable for Palestinian people living in Gaza. Take a look at this map, for example. You know, this is truly an open-air prison. You know, the fences are so tough. It's, you know, has 3 dimensions, and also they occupy territorial waters of Gaza, and also they controlled air. So they controlled everything in order to attempt genocide, but they failed. But, you know, for the last 2 years, unfortunately, genocide happened. So I'd like to take your attention to the very definition of genocide itself from the Genocide Convention. So, Article 2 of the Genocide Convention, as you all know, defines the genocide as certain prohibited acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. Among these acts, one provision is particularly important for understanding the situation in terms of Gaza blockade. The Article C. Please pay attention. It says that deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. So, when you impose unlivable conditions through blockade, you are creating unlivable conditions that might lead to destruction of the people in whole or in part living in Gaza. So, Genocide Convention doesn't punish not only committing genocide, it also punishes or prohibits the attempt to commit genocide. So my point here is the blockade itself was an attempt to genocide. Then Israel tried several times to do actual genocide. Remember, they tried many times to invade Gaza, but they failed, at least until the 7th of October. So that's why the events of 7th of October didn't emerge from a vacuum. So Israel created genocidal, unlivable conditions in Gaza. So these suffocating conditions somehow led to uprising in order to, turn the situation much better or regain the livable conditions. So that's why my point is, why not to assess legally the blockade itself started in 2007 is an attempt to commit genocide that led to actual genocide after the 7th of October. Take a look at this, for example, visual, Israel controlled Gaza from land, air, and sea. The economic conditions, the health conditions, water, sanitation, everything, weakened, and Gaza was becoming unlivable. So the blockade itself weakened civilian infrastructure, devastating healthcare system, and created long-term humanitarian dependency. So that's why these conditions, I'd like to, legally assess these conditions itself was an attempt to genocide. So take a look at the access to water of, Gaza is way less than, what UN experts, described for human living. This is another visual for, how Gaza was using or lost the 97% of water even before the genocide, This is a visual from November 2023. So that's why the situation is much more worse today. So today is Israel committing actual textbook genocide. So gradually, the colonial isolation of Gaza and the blockade itself started the attempt of genocide, and from 2023 we have seen the actual genocide committed by Israel. So what are the legal obligations upon the third states here? So these legal obligations basically summarized by International Court of Justice in the advisory opinion of 2024. The court somehow emphasized several key duties of states. So basically, states must not recognize unlawful situations created by force. Then state must not aid or assist the maintenance of unlawful occupation, and states must distinguish between Israel and the occupied Palestinian territories. And also states must cooperate to end the unlawful situations through the lawful means. So these are not political preferences, they are legal obligations, revealed by International Court of Justice. So what state did actually not satisfying states. Some of them were complicit in genocide, some of them were aiding and abetting, for example, the United States, and some of them failed the collective responsibility, at least, failing in cooperation with United Nations. So what about U.S. position? U.S. position is one to specifically should be addressed, because U.S. is also party to Genocide Convention. They also have a legal obligation to prevent genocide. But apart from doing that, U.S. vetoes in Security Council, more than half of it used to back Israel's actions. You can see here, the total 79 total US vetoes of the 42 US vetoes out of 79 is just used for Israel. So US and through US, UN Security Council also failed its obligations. So this is Gaza today, still suffocating, still facing genocide, and states doing nothing. So, in conclusion, Gaza is not only a humanitarian tragedy, so it's also a moral and legal test for the international system itself. Thank you very much for your attention.
Hello. That would be me. Hi all, thank you for showing up. So I just want to sort of run you through one of my sort of permanent ideas about international organizations, how I can apply that to international, there's no international organization, the Board of Peace, and how there's a consistent theme across centuries and even decades recently as well, there's that colonial continuance in the design of international organizations. And I'm going to treat the Board of Peace as an entity, as an international institution in that sense, and how it sort of reveals a wicked design in itself, which is also consistent with the historical examples that we have seen in the colonial and neo-colonial period. So I want to start with the obligation we have here. So the ICJ in its July 2024 opinion stated that all states should ensure that any impediment resulting from the illegal presence of Israel in the occupied Palestinian territory to the exercise of the Palestinian people of its right to self-determination should bring an end to these sort of impediments, and indicated that the precise modalities of this obligation will be determined, or can be determined by the General Assembly and the Security Council. So what we see here is that sort of like there are sort of obstructions that are put in place before the Palestinian liberation, and the court is asking all states, all subjects of international law to remove them. That's like a very all-encompassing, wide-ranging, and some might call it a government's obligation that falls upon all entities under international law. And if you can also see that this is a proactive obligation, so it's not an obligation to stay away, to not prevent. It's an active obligation that you should work for to remove all those impediments before the Palestinian liberation and self-determination. And what we also have in this context of Flotilla is the humanitarian access. And all the civilian initiatives are trying to do is to deliver the necessary, the basic minimum that we all should do to deliver some basic aid to those people who are under an ongoing genocide. So we have two different obligations. One is a much higher one to remove all impediments before the liberation. And there is also that minimum obligation, which is to provide some form of humanitarian relief and enable humanitarian access. And again, humanitarian relief, humanitarian access obligation is a proactive one. So you have to, even Israel itself should facilitate and enable that obligation. It's not an obligation to stay away before the sort of flotilla, for instance. So you have to actively facilitate it. So what we see here is that, so in this sense, if you look at the court's design of the obligation, from this perspective, humanitarian access is not something that is a reduction of that broader obligation to remove all the impediments before the Palestinian self-determination. So that first obligation encompasses the obligation to facilitate and enable humanitarian access. And keeping that in mind, that effectively means that Israel should still need to respect and facilitate that access, humanitarian access, under its obligation to remove the impediments before the Palestinian liberation. So there's somewhat an overlap in that sense. And what we see in the context of the Board of Peace is the establishment of an international organization. And what it does is, in even the court's opinion, it says is the precise modalities of that obligation will be determined by General Assembly and the Security Council. So there's some form of expectation on the part of international organizations to provide something to materialize that obligation. So there is an institutional work that needs to be done. And the Board of Peace sort of like intervenes at that point, but it does the exact opposite that the obligation tries to deliver. But still necessarily retains those typical features of international organizations, which also feature that colonial character. What we see is the establishment of an international personality, and what we also see two typical functionalist elements. One is the all necessary things that an international organization will need are also sort of provided to this new entity. So it says, authorizes member states participating in BOP and BOP to enter into such arrangement as may be necessary to achieve the objectives of the comprehensive plan. So this is one of the typical features of international organizations. Organizations are giving a sort of a wide-ranging opportunity to do anything that is necessary, that is anything possible to deliver, to materialize, to fulfill the objective. Whether the objective is a good one or not, that's like a separate issue, but this is one of the typical features. And then we also have that technical functions element there, and it is indicated by, in the resolution by saying that Gaza will be governed under the temporary transitional governance of a technocratic, apolitical Palestinian committee responsible for delivering the day-to-day running of public services and municipalities for for the people in Gaza. So this is again that technocratic and apolitic element is again a typical feature of international organizations, where the organization seems to be doing a non-political work, purely technical, just delivering the aims and objectives that are provided in the mandate of the organization. And what you also see is again a Good Samaritan feature here. So you're one of the essential questions before anyone studying international organizations is whether international organizations provide or deliver the image of a Good Samaritan. And recently that status has taken a little hit, and the organizations are no longer seen as purely Good Samaritan entities delivering and working for the good of humanity and the international community. You can also see that example here. Your straightforward answer to the work in the context of the work of the World of Peace, but whether you can consider it as a positive development in the context of the ongoing genocide, you probably would say, and that the work is not necessarily a positive one. So that Good Samaritan status is also out there, which will also I also highlight down the road. So this is again like a typical features of international organization. We have that a wide-ranging obligation falling upon all entities under international law, effectively incorporating organizations and states. And now we have sort of like a baby international organization, a transitional entity that is supposed to be working for the good of the Palestinians and Gazans. But what we identify in the context of institutional work is that there's something what I term as colonial benevolence. And I think this is like a very permanent theme across centuries in the context of the institutional work and institutional design. And what institutions does is that they effectively perpetuate that colonial character in the context of the post-colonial period. So I identify three elements here. One is the idea of parsimonious master, and the second is colonial benevolence, and the third one is the entrepreneurial nature of colonialism. So all these three elements are quite they feature in many institutional activities which are sort of like consistent themes. Your probably first question is like, how do we identify benevolence here? And if you look at the colonial context, you would say that civilizing mission is the so-called benevolent character of that colonial project. And if you look at the international interventions, what you can see is multinational and international forces bringing security and stability and acting as good Samaritans for the people in some of the regions, especially in the third world. So that act of bringing security, peace, order, stability, development, all those features are actually sort of benevolent features supposed to bring good for those people in those areas. And you again can notice these elements in the context of the Board of Peace. But what we first identify is that sort of that colonial benevolence has that sort of ironic character in it, right? Like it's not necessarily supposed to benefit the colonized or that those people who are victimized by the colonizer. So what you can see is that there is an element of prioritization in the first place. The colonial benevolence, is that character itself, prioritizes the colonizer and the aggressor itself. So if you look at the context of the Board of Peace, what you can see, there's a security aspect which is kind of prioritized over Palestinian liberation. And when the plan lists its sort of like objectives, the first thing that is mentioned is that Gaza will be de-radicalized, terror-free zone that does not pose a threat to its neighbors. So the first thing that comes to the board's mind is that Gaza is a threat to a neighbor, and that neighbor is this genocidal state, genocidal regime of Israel. And in the second place, the plan mentions that the Gaza will be redeveloped for the benefit of the people of Gaza who have suffered more than enough. Again, you have that missing aggressor, which is effectively mentioned as a neighbor in the first place. So there is an element of prioritization of the aggressor, of the colonizer, over the colonized people. And that is the sort of like a typical feature of colonial benevolence. And again, you can read through the benevolence element here that the Gaza will be redeveloped for the benefit of the people of Gaza. Again, ignoring all the suffering they've been through during the ongoing genocide there. So that is, again, an element of prioritization, which is quite remarkable there. And if you consider that in light of the remarks of the ICJ, you can see the opposite here. So again in July, the court said that it considers that Israel's policies and practices obstruct the right of the Palestinian people freely to determine its political status and pursue economic and social cultural development. And it went on saying that this is the territory unit across which Israel has imposed policies and practices to fragment and frustrate the ability of the Palestinian people to exercise its right to self-determination. And so you can see the contrast here. The first thing is that we had one obligation, which I said, like, this is the sort of the all-encompassing, the highest obligation that we have, is that we have to remove the impediments before the Palestinian liberation. And the court states effectively that that obstruction is the genocidal Israeli regime. That is the thing that is actually effectively preventing the materialization of Palestinian self-determination and liberalization in the first place. So that is it is the primary role of Israel that needs to be mentioned in the first place, which perpetuates the Palestinian suffering, as opposed to putting Gaza and Palestinian as a threat to that aggressor, that same aggressor, that is the impediment for their redevelopment, for their sort of self-determination. So that is kind of like a weird prioritization regime that is put in place by these organizations which effectively prioritize that colonizer actor there. And in the second place, alongside security, what you also see that development element as a secondary feature of that benevolence feature. So what you see is that, for instance, in announcing the Trump's plan, kind of proudly announcing the plan, the way they phrase it, or the way they want to sort of promote it. It says, President Trump ratifies Board of Peace in historic ceremony, opening path to hope and dignity for Gazans. And so you can see that there's some sort of it effectively conveys that sentiment that they are actually materializing something good for the people of Gaza. And it carries on saying that this is another pivotal step forward in realizing President Trump's vision of transforming Gaza from a region plagued by conflict and despair into one defined by opportunity, hope, and vitality. So consider the last element of vitality here vis-a-vis the ongoing genocide and the killing of Palestinians by Israel. So it completely ignores the suffering, the plight of Palestinians, the things that they're going through, and simply sort of tries to promote and advertise this plan as somewhat a hope for them. And again, carries on, it says, together we are in a position to have any credible chance to end decades of suffering, stop generations of hatred and bloodshed, and forge a beautiful, everlasting and glorious peace for that region. So if you look at the wording, it sounds as if there's that sort of beautiful feature that's laying before the Palestinians, just because there's no initiative which is started by the Trump administration. So that element of sort of benevolence provided to the colonized people is quite a sort of like a direct feature that you can easily notice in even the sort of like the initial statements of those project makers. So this is that sort of like the colonial benevolence element there. And then what you also have is that parsimonious master, which is kind of like that stingy master doesn't necessarily want to provide it actually. So that benevolence will not be materialized, and the master doesn't want to bear the cost of it. And what I identified as feature in the context of the United Nations in Haiti, the UN was quite unwilling to pay for the intervention, even though it was the entity that was sort of authorizing it, that was kind of making it possible for the US government to intervene in Haiti in 1994. But the unwillingness to pay was quite sort of apparent, that the intervener should bear the costs of the intervention. So you can also see the same element of parsimonious master in the context of the Board of Peace. You can see in between the paragraphs that this new initiative will be funded through voluntary contributions from donors and BOP funding vehicles and governments, or through the World Bank and other financial institutions, which effectively means the Gulf states, or a dedicated trust fund for this purpose and will be established and governed by donors, again meaning the Gulf states in this context. And the ISF will be funded through voluntary contributions from donors and BOP funding vehicles and government. So that element of sort of that parsimonious stingy master that doesn't even willing to pay for its interventionist aggressive policies tries to kind of manipulate that funding element, which is, again, I think it's quite a sort of like a permanent theme in the context of the UN is trying to avoid shouldering its financial responsibilities and try to sort of have intervening states to carry the financial burden. The Board of Peace does the same thing and tries to have the regional states to carry the financial burden for its own intervention and project. And what you also see, that element of entrepreneurial nature of colonialism, that's kind of like a projectification of this intervention in the region. That technographic and technical element, technocratic governance, is again part of that projectification and acting as a risk taker and businessman. You can see the similar features in that context of transitional governance. There's an element of opportunism, and also in the sense of like you are acting as an entity, as a project that is providing opportunities to the region and to the people in the region, and you can sort of read through it in the comprehensive plan here. So if I can sort of read it to you, it says, a Trump economic development plan to rebuild and energize Gaza will be created by convening a panel of experts who have helped birth some of the thriving modern miracle cities in the Middle East. So it kind of like places Gaza as a project city, as one of those Gulf cities, which will be energized by the opportunities created by this board. And it carries on with similar wordings. It says, many total investment proposal and exciting development ideas have been crafted by well-meaning international groups and will be considered to synthesize security and governance framework to attract and facilitate these investments that will create jobs, opportunity, and hope for future Gaza. And again, similarly, it says, we will encourage people to stay and offer them opportunity to build a better Gaza. So there is somewhat an opportunity that will be provided by this colonial project to the people of Gaza, and that is the selling point of this entire colonial project. So I kind of like identify all these three elements, starting with that colonial, benevolent dynamic, and then going with that parsimonious, stingy master, and then that entrepreneurial nature of colonialism, which again features in the context of Board of Peace. So all these three elements, what they do is what they effectively justify the work of the institution. So it justifies the actions of an institutions. Institutions are effectively empowered by their initiators, but they are also kind of like a self-running, living creature that has almost absolute powers in the context of their activities. So if you recall the wordings that I mentioned, that all the necessary activities that are necessary, that are required to achieve the objectives of the institution are allowed and are actually sort of authorized for the organization to carry them out. So organizations, they have these absolute powers within the limits of their mandate to do everything that they want to do. So what this does, it gives them a technical spectrum to justify their actions. But you also do need a moral dimension which you use other elements to justify them with. And in this context, these elements of benevolence is quite useful to justify the institutional action. And you are effectively justifying that all-encompassing capacity to act in a region suffering from an ongoing genocide by reference to that element of benevolence. The trouble here is that what Sumud in this context does is it exposes this wicked colonial design here. So this justification mechanism of benevolence is exposed by the initiative, by the civilian initiative. Because if you look at the response of the board or the Trump administration, who is the sort of sponsor of this Board of Peace project here, what you can see is that there is somewhat a monopoly over action. So there is a monopoly over who can actually carry, who can actually deliver humanitarian aid, who can provide humanitarian access. So you as an individual, as a civilian who's a subject of international law, empowered by international law in the sense of that you have rights and obligations that allow you to carry this mission out. What the Board of Peace does is it effectively tells you that you have to direct your initiative to these supposed legitimate channels of providing humanitarian access. So it effectively delegitimizes that external civilian initiative, and in this context the Global Sumud Flotilla, and it attempts to establish a monopoly over international action. This reveals that colonial dynamic once again. So we did mention that it is not only benevolence, it's colonial benevolence that features in institutional designs. So this response to the action by civilian initiatives reveals that character of that colonial character who is trying to monopolize over that institution, over that international action. And response reveals that character of that wicked character. And you can also see that in the sense of the board and the administration attempts to identify, treats them as tries to sort of terrorize them, and even sort of directs them to put pressure to liberation groups, which is not necessarily relevant in this context of what they do in terms of delivering aid to individuals who are victimized by the ongoing genocide in Gaza. And so what I just sort of like end with is that what Sumud does in this context, it effectively exposes and reveals that colonial character in institutional designs, that by simply indicating or by simply advertising and announcing that their actions will be beneficial, that their actions will be done for the good of humanity or in the name of international community, that doesn't necessarily mean that these activities are carried out for the good of humanity, given the way they prioritize decolonizer as opposed to decolonized. And I just want to end here and thank you all for listening.
Hello again. First of all, we're so happy to see our Global Sumud Flotilla activists joining us here on this conference hall. And now we will proceed with the second session entitled State Responsibility, International Criminal Accountability, and Third State Obligations. I would like to invite our moderator for this session, Ms. Natalia Asioli, and followed by our esteemed speakers, Ms. Ayşe Didem Sezgin, Mr. Mehmet Emin Büyük, and Mr. Hamza Ünal, who will be joining us later. Please welcome.
Hello. Distinguished guests, esteemed colleagues, comrades from all around the world, and welcome to session 2 entitled State Responsibility, International Criminal Accountability, and Third State Obligation. The session will address questions concerning state responsibility under international law, international criminal accountability, under international law, international criminal accountability, obligations of third states, and legal responses to humanitarian crises in the context of the Global Sumud Flotilla in Gaza. I kindly ask all the speakers to observe the allocated time of 15 minutes for the presentations. And our first speaker is Mehmet Emin Büyük, Assistant Professor, IBN Haldun University, presenting Reframing International Law, Necessity, Cumulative Practice, and Direction. Thank you.
Dear colleagues and friends, I want to start by thanking the organizers of this organization for putting this program together. It was very hard job, I assume. I'm an international lawyer as an academic, and I usually work on issues of general international law, what I like to call. This also international law, the theory, the history of international law, theoretical debates, etc. So as long as I want to stay between the topics of this session, I just want to give some general perspectives for today's problems in my work. Today, international law is facing some very serious crises. Multilateralism in particular taking serious hits. We are seeing fewer multilateral treaties being concluded, and states that are already party to this kind of treaties are withdrawn. Even in our classrooms, the question of whether international law is actually does anything useful or does it exist keeps coming up. And here's the thing. When an international lawyer stands up and says, yes, international law exists and it matters, it can easily look like they are just defending their own faith. And I'm not comfortable with that, defending my own faith. And that's not I'm here for today. Now, there are few familiar arguments that usually come up when people try to defend international law. First, they say domestic legal systems are full of violations too, and yet nobody questions questions whether they count as law or not. So violations can't be the test. The second one, they say the vast majority of interactions between states actually happen in accordance with international law and its rules. So violations are the exception, but they just happen to be visible and well reported. Third one, they say having a rule and following a rule are two different things. Non-compliance is a breach, not proof of the rule that doesn't exist. So let's leave the practice out of the classroom and just focus on the rules. Okay, I'm not saying these arguments are wrong. They are not wrong entirely, of course. But they have been argued enough times. And frankly, I'm not sure that these arguments get us anywhere. They don't help us figure out what to do or why our works matter. So I'm going to just note them. Now you heard them, and let us move on. I don't give weight to these arguments because I think we have been asking the wrong question. In my opinion, is international law effective or ineffective is the wrong question. The right question, in my opinion, is this field necessary? Or in other words, is international law is international law a systemic necessity? If the answer is yes to these questions, and I will argue that it has to be yes, then we really need to talk about is not its ineffectiveness, but its direction. To prove the necessity I'm referring to, let me propose a theoretical scenario. Imagine two neighboring modern states side by side, state A and state B, and these two modern states consider themselves as the highest authority there. They do not take orders from any higher authority. They make and enforce their own rules. So the first question comes up, what about the rules between them? But another question arises, do they need this kind of rules or some rules? And let's take this forward. Assume they have no relationship whatsoever. No trade, no shared river, no movement of people from across one border to another. Zero contact. There is zero contact between them. Now let's think about this. Can we still speak of rules that must be observed between them? This is the question. Or can we say that there is truly no relationship at all, so we do not need any rules of this kind? My answer is that no. There is in fact one relation remains. That's the border. The moment they agree on that border, the moment they recognize each other as states, a legal relationship comes to existence. Nobody chose this. It is the logical and systemic consequence of the modern state system. And add trade, add shared river, add movement of people on that, and now this relationship deepens. Rules multiply and diversify. So we actually reach international with this background, this theoretical background. I hope I'm not moving too fast with these theoretical backgrounds, but I'm coming to another thing with us. State theorists tell us that state exists within a system of states. If we are talking about modern states, we are necessarily talking about a system of states. The legal consequence of this is clear. International law is not a constraint imposed on the state from outside. It is the state's logical extension. The question whether international law should exist is therefore meaningless. As long as the modern state system exists, this field will exist by necessity. So from here, the real question is, who will shape international law and how and in whose interest? Answering that question with not us, we are not going to deal with this kind of stuff, is not an option. Because when we step back, the field doesn't remain empty. It simply fills someone else's values. Let me give you a concrete example on this point. Usually we side with natural law when we try to come against powerless states and their ambitions, right? But listen to this positivist story. In the 19th century, European states, European great powers, repeatedly intervened in Latin American states, using the excuse of protecting their investors and collecting debts. In response, Latin American states and scholars developed a legal answer from a positivist point of view. The Carbo Doctrine held that foreign investors must exhaust local remedies before seeking diplomatic protection, and there must be equal protection for citizens and foreigners. Also, the Carbo Doctrine defined use of force for debt collection a violation of international law. These doctrines were rejected by the great powers of that time. Today, these doctrines are fundamental reference points in international investment law and debates on state sovereignty. Latin America didn't turn its back on the field, on international law. It rewrote the field from its own perspective. When you examine every institution, every norm, every mechanism that international law possesses today, you find the same thing. None of it came from nowhere. Behind each one is an act that seemed disproportionate at that time, often solitary, often with certain outcome. No certain outcome, sorry. Let me give you some examples on this point. In 1625, Hugo Grotius wrote the Belli Akbesis, right? In the middle of 30 Years' War, Europe was burning. There were no international institutions, no enforcement mechanisms. Grotius knew this and wrote it anyway. That book laid the intellectual foundation for Peace of Westphalia in 1648. The legal framework of the modern state system grew out of a book written in the middle of war. Another example, Jay Treaty of 1794. It was between the United States and Great Britain. It is considered the first step towards modern international arbitration. It was not even a proper arbitration mechanism by the standards of today's arbitration. It was modest and flawed, but the step was taken. Over the next 2 centuries, that seed grew with Permanent Court of Arbitration, Permanent Court of International Justice, and International Court of Justice, and International Criminal Court. Today, there are dozens of cases where states have gone to court instead of going to war. And all of them trace back to that flawed treaty. A third example, in the second half of the 19th century, peace societies began forming in different cities across Europe. They rarely taken seriously at the beginning, but they persisted. That accumulation laid the groundwork for peace conferences. Then, with the United Nations Charter, war has been prohibited entirely. A fourth example, in 1859, Henry I witnessed thousands of wounded soldiers left on the battlefield after the Battle of Solferino. He helped. Then he went home and wrote about what he had seen. That book triggered the founding the International Committee of Red Cross and now Red Crescent. Donald himself spent his later years in poverty, alone in a small room. But that spark grew, and the first Geneva Convention was signed in 1864, sorry. And now there are 4 conventions and with additional protocols, and there are great conventions and treaties on humanitarian law. Looking at these 4 chains, a common pattern emerges. Each began with a small act that seems disproportionate at that time. In each case, the result came decades, sometimes centuries later. And each case, the starting point was a moment of crisis. You might find this chronology too Western-centric, of course. However, international law is a field capable of transcending these boundaries. The 1955 London Conference and 1963 Addis Ababa Summit demonstrate how anti-colonial movements transform self-determination into a fundamental legal right. This process continues today. For instance, small states like Vanuatu taking major industrialist nations to court over climate change responsibility. The Namibia case, I will discuss shortly, further proves how this global south perspective has successfully transformed the system from within. Of course, there is still no normative, central and hierarchical enforcement mechanism. Even after all these processes, there still is none. That has to be acknowledged, of course. But what do we see is this. Processes produce norms, and norms makes new processes possible. This spiral doesn't always move forward. It stalls, reverses, stops maybe. But when it does move forward, it leaves lasting marks. Southwest Africa, Namibia as it is known today, is one of the clearest examples of this spiral. This is a region that, like Palestine, suffered under a mandate system. That is why I found Namibian experience worthy known. In 1920, Southwest Africa come under South African Mandate C. The advisory opinions issued by International Court of Justice in the 50s prevented annexation but didn't produce independence. Apartheid was formally extended to territory by South Africa. Then in 1960, the Second Conference of Independent African States made a strategic decision. They said, stay within the system, bring a case before International Court of Justice. This choice matters. It was newly independent states choosing to use the system from within rather than rejecting from it outside. Ethiopia and Liberia brought this case. In 1962, the court decided it can pass the merits of the case with a close vote 8 to 7. Then came the crushing blow of 1966. A 7-7 vote with changing majority, you all know that, decided by the president's casting vote. The case was dismissed on grounds of standing without reaching to merits. For anyone present that day, it felt like the collapse of the system of international law. But the accumulation didn't stop. The General Assembly terminated the mandate. The Security Council endorsed it. The court corrected its earlier position with a changed majority, confirmed it in 1971. In 1999, Namibia achieved independence 70 years after the process began. What would have happened if the struggle had been abandoned after 66 decision? Namibia might have freed eventually. But how, when, and what cost? We cannot know that. The accumulation made a difference. A similar pattern can be seen in Nagorno-Karabakh issue. For decades, Azerbaijan remained trapped in negotiation and mediation processes that pursued nothing. Every platform stalled, but in each of them, Azerbaijan's legal entitlement was formally acknowledged. That accumulation ultimately provided the foundation for military, diplomatic, and legal legitimacy alike. Without that legal persistence, would even a military success have been recognized so ambiguously? We can also see the ground expanding. In 1990s, during Rwanda and Srebrenica, access to international legal mechanism was severely limited. In 2023, South Africa brought a case against Israel before International Court of Justice. A small state took a state backed by the world's most powerful military supporters to an international court. Whatever the outcome of that case, the capacity itself is an achievement. That capacity didn't exist in the 90s. It exists today. The world has Okay, the world has always worked in this way. Of course, in Grotius's time, in Dunan's time, in the time of naval applicants, power politics has always coexisted with international law. We agree on that. And it will continue to do so. Pretending otherwise is neither honest nor useful. It is the same today. I'm not here to soften the reality or just pretend there are quick solutions. But we also see this. Even in the middle of power politics, even in the middle of great wars, legal accumulation makes a difference. It shapes the process, influences the outcome, and builds the legitimacy of that outcome. And every time what starts that accumulation is an act that seems disproportionate, often solitary, often with no certain outcome. Grotius wrote in the middle of the war, Dunan came back from a battlefield and acted. The peace societies remain marginal but persistent, etc. After the devastation of 66 decision, the Namibia applicants didn't give up. South Africa knocked on the court's door. The same pattern is visible today. Every UN report prepared on Gaza, every initiative brought before international institutions, every attempt to deliver aid, none of these produce immediate results. But they name the violation, record it, and fix it in the historical record. That documentation is the raw material of accumulation. Beyond that, when international law defines a violation, that definition reaches the public, and the public can translate that definition into something concrete. Boycotts, political pressure, diplomatic costs. International law does not apply that pressure itself, but it provides the language and the ground that makes collective action possible. That too is a form of effectiveness. When all of these share is this, the insistence on shaping the direction of a field whose existence is necessary. To walk away is to give up on answering that question. And when we give up, the field doesn't stay empty. It simply fills with someone else's values. That's the end of my presentation. Thank you very much.
Thank you very much, Mr. Buick. Now, our next speaker will be Mr. Hamza Now, PhD candidate in Istanbul University, presenting state obligations under international humanitarian law in the context of the Global Sumud Overland Convoy. Please, 15 minutes. Okay.
I'm trying to not exceed my time, and I would like to use presentation. While it has been preparing, I can start. Actually, we were participating to the testimonies. The participants who are endured the interception, and we get here a little bit later. I'm so sorry about that. So, the humanitarian situation in Gaza has been covered extensively this morning, and the GSF's legal strategy has just outlined, so I will go straight to the point. What does international law actually require from the countries this convoy passes through? And I have a main question here. A civilian convoy is driving across North Africa to deliver food and medical supplies to the people who are enduring genocide and re-emerging famine. It passes through Mauritania, Algeria, Tunisia, Libya, and Egypt to reach Rafah border. It has 1,500 to 2,000 people including 300 doctors, engineers, and lawyers. It carries humanitarian aid trucks, and it complies with every country's customs and immigration rules. So here is the question, which is very simple. Can a transit state legally say no? And if it does, what are the consequences? The answer, as I will show you, is that they cannot, and the consequences are really serious for them. It was my legal question. It is the main question of my presentation. So I can get to the directly to the Fourth Geneva Convention. Let's start with the basics. The Fourth Geneva Convention has 4 provisions that work together. Article 23 says that all states must allow free passage of food, medicine, and relief supplies for civilians. Not may allow, it says shall allow. And Article 55 says the occupying power must make sure the occupied population has enough food and medicine. Israel has clearly failed this, and there is a phase 5 famine has declared already. And here is where it gets interesting. Article 59 says when the occupied population doesn't have enough, which it doesn't, then all states must let relief supplies through and must protect those supplies. Again, the tone is that shall permit, shall guarantee. There is no wiggle room in this language. Article 70, as you can see below of the presentation, maybe you cannot see from the screen. It is the Article 70 of Additional Protocol 1 goes even further. States shall allow and facilitate rapid and unimpeded passage of all relief supplies, equipment, and personnel. The key point is that these aren't obligations just for the countries at war. They bind every state the convoy passes through. Every single transit country is a part to the Geneva Convention. This is a treaty of obligation, not a favor. So we call them as a jus cogens norms. We can get to the Genocide Convention. Now it gets heavier. In September 2025, the United Nations Commission of Inquiry found that Israel has committed genocide under 4 of 5 acts listed in the Genocide Convention, including deliberately starving people. The ICJ told in Bosnia versus Serbia case that the duty to prevent genocide means you have to use every reasonable means available to the states. And Common Article 1 says all states must ensure respect for the Geneva Conventions in all circumstances. So here is the bottom line. If a transit state blocks a humanitarian convoy that's heading to a population facing genocide, a convoy carrying food and medicine, that state risks being complicit in failing to prevent genocide. And it is not like my opinion, that is the legal logic of the convention and the ICJ's own case law. The ICJ has been remarkably active on this. The 3 binding provisional measures ordered in 2024 alone, the March order specifically demanded unhindered provision at scale of humanitarian aid. Then 2 advisory opinions, July 2024, the occupation is unlawful and all states are obligated not to help maintain it. In October 2025, cooperation with humanitarian operation is non-derogable, meaning you cannot opt out. And here is the simple logic. You can't say that you are complying with ICJ's demand for unhindered provision at scale while you are blocking a humanitarian convoy at the border. Those two things are incompatible. And the Rome Statute makes starvation as a method of warfare a war crime. That's Article 8, Paragraph 2b and 25. The ICC issued arrest warrants in November 2024 under exactly this provision. But there is another article that matters for transit states, Article 25. It says anyone who aids or assists in the commission of a crime is also criminally responsible. So obstruction of relief in a recognized starvation campaign doesn't just affect the primary perpetrators. It has consequences for anyone who helps, including by omission. And the ICC Appeals Chamber confirmed its jurisdiction over Palestine in December 2025. This is not a hypothetical court, it is an active one. And we can get to the Security Council resolutions numbered 2720 and the other one. In these resolutions, Security Council demanded immediate, safe and unhindered humanitarian delivery. Under Article 25 of the United Nations Charter, all member states have to carry out Security Council decisions. All member states, including every transit country on this road, and it is a binding obligation for transit states as well. And here is the main point of us we get here. It is transit state obligations. So let me pull it together. Mauritania, Algeria, Tunisia, and Libya have direct obligations under the Geneva Convention and the additional protocol to let the convoy through and to protect it. Now, I know the anticipated responses. We have administrative procedures, there are bilateral considerations, and it is complicated. And none of that works for our case, for our land convoy. Administrative procedures cannot override a territory obligation, and bilateral political considerations cannot override a jus cogens norms, a perpetuatory rule that sits at the top of the international legal hierarchy. So you cannot use a bureaucratic stamp to block compliance with the Genocide Convention. And Egypt is the most vital one and the critical case. It controls the Rafah crossing border, the only way into the Gaza that Israel doesn't directly control. And the Rafah has been effectively closed since Iran war to 28th of February. And Egypt's obligation comes from everything I have just laid out. But there is another additional layer. Article 16th of the ILS Articles on States' Responsibility says that if you help another state commit an international wrongful act and you know what is happening and you are responsible too. So think about what Egypt knows. ICC arrest warrants are in force for starvation, and the ICJ has ordered unhindered aid delivery. The United Nations Commission has found genocide, and aid deliveries have dropped by 80%. And the Egypt controls the only door. In those circumstances, keeping the door closed isn't just a policy decision, it's an omission that may cross the legal threshold of complicity. That is the question Egypt's government needs to answer. By the way, maybe you can have a question that if Egypt says that we can take humanitarian aid from the Global Sumud Flotilla, and they may demand that we would get into bilateral negotiation with Israel, and we would give them to the Gaza people. But it is not accepted, because under Additional Protocol 1, Article 70, Paragraph 3, is very clear. A transit state has what is called a right of control. It can search the cargo, it can set the road, it can set the timing. That is all legitimate for Egypt. But Article 70, Paragraph 3, says that distribution must be supervised by an impartial humanitarian organization, not by the transit state itself. And Article 70, Paragraph 3 and subparagraph C says, relief consignments shall in no way whatsoever be diverted from their purpose, nor delayed. So, which means that Egypt can inspect, but cannot take humanitarian aid, and they cannot give them to the Gazan people by themselves. The international organization or civil organization shall do that. Yeah, and we have learned some lessons from the previous land convoy. 1,070 people was blocked at the Sirt crossing and denied entry into Egypt. 13 people were detained. We learned from that, and this time over 100 diplomatic communications have already been sent in advance. We have pre-drafted legal letters ready to deploy at every stage. We have identified that the Vienna Convention consular access, which is Article 36, is the single most effective tool when detentions happen. And we have coordinated national legal teams for rapid response. The legal framework is now matched by operational preparedness. And let me close with this. The accountability infrastructure is shown by my presentation. Istanbul Public Prosecutor's Office has issued 37 arrest warrants and filed an indictment against 35 suspects, including the Prime Minister of Israel has last month. So Spain has universal jurisdiction proceedings. Italy and the UK have active investigations on that. The ICC has confirmed its jurisdiction, and transit states needs to decide which side of this framework they want to be on. And here is my conclusion. Every point is in the same direction. The Geneva Conventions, the Genocide Convention, the ICJ, the ICC, the Security Council decision, they all the same thing. Let the aid through. Facilitation is not just allowed, it is required. Those who facilitate are upholding the law. Those who obstruct are placing themselves on the wrong side of a regime of accountability that is no longer hypothetical. It is operational, it's expanding, and it has consequences. Thank you.
Thank you, Mr. Yunal. Now you'll hear from Mrs. Ayşe Didan Sizgi. Didan? Assistant Professor in Muğla University, presenting Connecting Starvation and Ecocide in Gaza, Israel Weaponization of Life Support Systems under the International Law.
just checking if I can make this work. Okay. Excellent. Thank you. I'm honored and delighted to be here, which I think is pretty much a miracle, considering my story since the 7th of October as an international law scholar. Similar to international laws. Oh, sure. Sorry. I'm just not very happy hearing my own voice. Okay. So, pretty much the rest of international law, I was feeling paralyzed, and my perspective on my own discipline and I guess the hope the civilian resistance brings sort of brought this CPR on this patient, and so I'm very much grateful for the organizers for showing activism, journalism, scholarly work coming together in an excellent way. So what I want to talk about very briefly is perhaps think through. Let's read environmental damage and starvation under a new light to assess how they might impact the legal test for genocide. So just to give perhaps a shortcut answer, and hopefully I will come to this point, environmental damage does not lower the thresholds, especially the mens rea, for genocide, but may help infer genocidal intent from a pattern of conduct. So let me show you the facts. Let me show you that the ecological and infrastructural conditions of survival are being dismantled. So the disappearance of olive trees in Palestine. Probably going much further, but let's start with 1967. Occupation begins. Palestinian agricultural land comes under occupation, affecting olive growing communities. Comes 1989, 30,000 fruit trees uprooted in a single year. The UN reporting describes large-scale uprooting. And up to 2013, 800,000 olive trees uprooted again. And this estimation, the most widely cited, especially by visualizing Palestine, which I'm using here, captures the scale of long-term loss. And doesn't stop here. In 2023, we also see harvest being blocked. The OCHA reported 96,000 dunams of olive cultivated land left unharvested. More than 1,000 metric tons of olive oil lost, and the direct loss being around $10 million US. It's today estimated that the numbers may have perhaps went up to 1 million olive trees. So, beginning with this, I would like to go back to this question, how may better situating or understanding the scale of environmental damage help us inferring this pattern to genocidal intent? Well, for this, I think it's also helpful to connect with starvation, not only as a means of food procurement, but as the systematic process of starvation, both as a war crime, but also as part of genocide. Under international humanitarian law, this conduct is prohibited. Starvation of civilians, as we all know, and the destruction, denial of any survival objects. So Article 54 and Article 14 of the Additional Protocol to the Geneva Convention provide this IHL bridge between starvation as a battlefield method and conditions of life as a genocidal framework. They do not themselves prove genocide, but they help show why the destruction or denial of food, water, agriculture, if we're talking about industrial style agriculture, fuel, sanitation, all the relevant things to maintain agricultural practices. And then the relief access, obviously, is not merely altogether, these elements are not merely humanitarian tragedy, it's actually a legally prohibited method of warfare. So starvation, while prohibited as a method of combat, what's also prohibited is interesting in our context. So attacking, destroying, removing, rendering useless objects indispensable to civilian survival, such as agricultural areas, crops, livestock, drinking water. So both these articles basically show that international humanitarian law already recognizes this as a prohibited method of warfare. But deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part have a more specific connection to environmental damage, especially objects indispensable to civilian survival. So the natural environment that allowed to build the food-producing capacity and the irrigation works. Furthermore, I mentioned the relevance of fuel, electricity. All these things may be considered as indispensable. So there is a legal significance.
So it is now time for our last third session, where we will learn about civil resistance, self-determination, and human rights at sea. We have our moderator here, Ms. Natavan Husseinova, with our most esteemed speakers, whom I didn't have to call to come to the stage. Thank you. Ms. Amina Shirazi, Mr. Emre Gökmenoğlu, and Mr. Hüseyin Dişli. Please welcome.
Distinguished guests, esteemed colleagues, ladies and gentlemen, first of all, I would like to welcome you all to the third session that is going to be entitled Civilian Resistance, Self-Determination, and Human Rights at the Sea. And we have here our three distinguished professors over today. And I would like our professors to try to make their speeches around 10 minutes so that we can have a great heated Q&A session. So it's my pleasure to first introduce Amina Shirazi, and please.
First of all, I want to thank the organizers of this incredible event. It's a great honor to host the brave flotilla sailors who are carrying our humanitarian dreams to the people that we love in Gaza. And I want to especially thank you for your courage, for your determination and your commitment. And I had structured my talk to basically address you. I've been told that I should just cut it short, which is fine, because in the interest of having a more lively discussion, I will endeavor to do so. So first of all, I want to talk about what the flotilla represents, and then I want to talk about what are some of the challenges this project faces. And then thirdly, I want to talk about other possibilities for resisting genocide and upholding the principles of international human rights. I'm specifically excluding the word law because international human rights are basically our God-given rights that we were born with. And we have them by virtue of being human beings. And just because they've been codified in the Geneva Convention or the Vienna Protocol or in any convention or treaty doesn't mean that they're limited or restricted at the pleasure of a state, because they're not given to us by a state, they're inherent in who we are. And before we had the United Nations, and before we had these mechanisms, and before we had any codified laws, we did have innate, inherent, immutable laws, which we can call just cogents. And those are norms, and just cogents, which is antagonistic to just dispositism, which is laws which only bind a government that is consenting to be governed by it. Just cogents is compelling law. In other words, it is what a government cannot discharge itself from the obligations that are imposed by the norms of just cogent. So, for example, the prohibition on genocide, on slavery, on piracy, these are customary just cogents norms. Following the Second World War, just cogents developed to include crimes against humanity, torture, cruel and inhuman treatment or punishment of war crimes. These norms are all inherently related to human rights and reflects the interests of the international community as a whole, not the narrow interests of only a particular state. And that brings a substantive normative impact of just cogents. These are the legal duties, in this case, owed by the state, not only to their own citizens, but to the international community at large. The prevention of genocide, of torture, slavery, crimes against humanity, reflects core values of international society that can never be violated under any circumstances. However, the international commitment to human rights protection has undergone a paradigm shift towards lawlessness and non-adherence to these fundamental just cogents norms, which has effectively resulted in vast derogations. The Flotilla project, in my opinion, is an effort to steer the international community to what we have deviated from. So while the people on the flotilla are driven by a moral and ethical imperative to bring humanitarian aid and the necessities of life to Palestinians, in fact, it's an international community of citizens who are opposed to the violation of just cogents norms. And they're challenging their governments to be compelled to not opt out of international norms that are compelling and that can never be derogated from. The flotilla also highlights the dysfunctional condition of the United Nations, specialized agencies, and international juridical order that no longer maintains, guards, or enforces international human rights or just cogents norms. The flotilla exemplifies the conscience of humanity and the desire and will of citizens to restore the legal framework to what it was intended to support, which was the modern human rights law that commenced after 1945 with the Charter of the United Nations and the convening of the International Tribunal at Nuremberg. Breaking the siege will have significant ramifications for the international legal and political arena, as the country of every citizen will be tasked with protecting those rights. In the words of Kofi Annan, quote, "States prove unworthy of this task when they violate the fundamental principles laid down in the Charter of the United Nations and when, far from being protectors of individuals, they become the tormentors." But you will be facing challenges, and the challenges are increased human rights and international law violations, as you've already witnessed by the Zionist entity, and not just immunity, but also the assistance afforded to it by international actors, governments, the complicity and failure of other states, especially of those with citizens on board who are forcibly seized, abducted, unlawfully detained, and that has exposed how states and their corporate allies have run roughshod over and trampled on fundamental human rights. Ever since its first voyage, the flotilla has been menaced by dramatic disrespect and non-adherence to the rule of law, including derogations from just coaches. From August 2008 to today, civilians have been sailing towards Gaza. Since then, Israel has been intercepting in international waters with impunity. In waters near Greece, an EU member state, Israel enjoys complete immunity for committing piracy and taking the sailors as prisoners to Israel with no legal justification or authority, which constitutes a war crime as well as derogation from just cogents. The failure of states to protect their citizens on the flotilla underscores the uncontrollable limitation of the flotilla in meeting its stated goals and objectives. It is vital for the human rights regime of law and order to recover its balance, and as lawyers, we should ride the sails of the brave activists engaged in mass civil disobedience and grassroots political action, as the current global fascist control techniques are unsustainable. There are other possibilities for resisting genocide and upholding international law, international human rights. And you'll have to forgive me, I'm a lawyer, so I have to think within that framework. But the BDS consumer campaign is imperative. Pursuing legal action against perpetrators as well as their entities, corporations, for enabling violations, whether by supplying arms or permitting human rights violations by utilizing international human rights law through both domestic and international legal framework and mechanism, has had no success. In Canada, the BDS movement mounted a website called Indigo Books Kills Kids, calling for a national boycott of the bookstore over its misuse of profits to fund a scholarship program for Canadians to live and study in Israel in exchange for serving in the Israeli military. Indigo sought an injunction to remove the website. And in 2004, the Federal Court of Canada granted it. They granted Indigo, Canada's largest bookstore chain, an injunction against the BDS activists, forcing them to remove the website used to educate and inform the public. So you see how law is used as an instrument to continue the oppression. However, despite this defeat, I am optimistic about international human rights being enforced through mobilization, and to be used as a tool, because both history and the rule of law is on the side of the people who oppose genocide. First, as citizens, we possess, wield, and can harness incredible power, especially when we act in harmony. As the UN Special Rapporteur Francesca Albanese recently said, power is generated by people who move in harmony, and the flotilla is moving in harmony. That mobilization, coupled with a legal framework to hold accountable those who are responsible and liable for committing, planning, and ordering, as well as executing and profiting from human rights abuses, can result in decisions which then form a stepping stone for consciousness raising. We witnessed this with the ICJ and the ICC decisions. As of late 2024, popular opinion turned in favor of freedom of Palestine against Israel, with the issuance of arrest warrants by the ICC and ICJ rulings in July 2004 that Israel's occupation is illegal and ordered it to end. Therefore, I believe we have both the power and the means. The governments who failed to act on the ICC and ICJ rulings know this, and this is why they have taken extraordinary measures to prevent their citizens from attempting to break Israel's blockade. But people have resisted these measures. Filing petitions with the UN, for example, South Korea designated Gaza as a travel ban zone. for Korean citizens and suspended passports of peace activists seeking to break Israeli siege. A petition was filed with the UN calling the prohibition an abuse of power and demanding the Korean government return the passport after it was suspended, restricting participation in the flotilla. Another example is the invocation of universal jurisdiction. We had a discussion about that earlier, to launch criminal investigations. Peru just did that against Israel and an Israeli soldier from the 424th Infantry Battalion. A formal order was issued on April 28, 2006 to inquire into allegations of war crimes, crimes against humanity, and genocide. The duty under the principle of universal jurisdiction to prosecute serious international crimes, irrespective of the perpetrator's nationality or location of the offense, is a valuable tool. It is grounded in the authority of the country's ratification of the 1949 Geneva Convention and the Rome Statute, specifically Article 146 of the Fourth Geneva Convention. Petitioning the International Criminal Court is another way to investigate American and Israeli companies and individuals who are complicit in gross human rights violations, and using domestic legislation for the investigation and prosecution of war crimes, genocides, and crimes against humanity. So in Canada, we have a War Crimes and Crimes Against Humanity Act, which implements the Rome Statute of the International Criminal Court, and it includes crimes committed outside of Canada as well as inside Canada. So Canada is just one of 124 countries that are signatories to the Rome Statute. And so all these countries are legally obligated to, quote, fully cooperate with the court in its investigation and prosecution of crimes within the jurisdiction of the court. Specifically, these countries must comply with requests for surrender, since the ICC relies on the cooperation of the states to bring suspects to trial. So, in addition to arresting suspects, we can also share information about the location of suspects, gather evidence, provide documents, seize assets. There's so much we can do. Governments must be petitioned and pressured and lobbied based on the landmark decisions of the ICJ and the ICC to trigger the obligation of erga omnes to intervene and cannot maintain a business as usual with the Zionist genocidal regime in Israel. The crimes laid out in the warrants are not committed only by Netanyahu and Gallant. Many Israeli political leaders, military personnel, civil society actors also share that responsibility. It is our duty to seek them out. And crimes are still being committed today, including the use of starvation as a weapon. As such, governments should cut off all diplomatic and economic relations with Israel that risk aiding and abetting these ongoing war crimes. This should include a comprehensive two-way arms embargo and to end to all Israeli strategic partnerships and agreements. In the end, I just want to say that sailing towards Gaza is an example of the kind of international pressure that is needed, and it connects the citizens who oppose genocide with the victims of genocide. It bridges the distance between the citizens in Gaza and the countries of the world of the flotilla. And this could lead to a bigger protest movement. And this is exactly why the flotilla has come under attack, not just from Israel, but from other governments as well. Whether or not your ships reach Gaza, the impetus for states to respect just cogent norms and trigger the obligation to apply international human rights will have been accomplished. Thank you.
Thank you so much, Ms. Shirazi. She is at the same time human rights lawyer, and she highlighted the importance of the flotilla as well as states' inability to react and protect their citizens. So thank you very much again. And now we are going to hear from Assistant Professor Mustafa Emre Gökmenoğlu from Hacettepe University. He will be presenting Asserting the Rights of Detained Protected Persons. Thank you.
I'll set my own timer. So Good afternoon. My role today is to analyze the legal architecture of Israeli laws that is and will be used to detain our esteemed activists if or when they are intercepted, and in what way Israel's conduct of the judicial and detention process breaches international law. As reiterated many times today, we witnessed the illegal detention of the GSF activists a while ago and saw the pictures of the detained activists with bruised faces, which nullifies any legal argument and much more. Still, this sole explanation of stating the start and conduct of detention are against international law is not enough to grasp the multiple layers of international law that Israel is very creative and crafty to violate. I divided my bit into two sections. In the first section, I will try to deal with the domestic security laws of Israel governing the activists' illegal detention, and I'll talk later on international law aspect of the series of illegal detentions again. Despite the fact that the international pressure was successful in Thiago's and Said's cases, I believe we can all agree that Israel's detention policy will not change anytime soon. I would like to give a caveat that the topic covering Israeli laws has no intention to endorse or concede the legality of Zionist actions. I commend the efforts of the legal team of the Adalat Legal Center, who consistently hindered the Israeli authorities from enjoying carte blanche when it comes to treatment to detainees. As common sense forces us to think, the activists are humanitarians. However, in the eyes of the Israeli legal system in 2026, they are being preemptively categorized as security threats. I will highlight how the law is being meant to keep activists in cells without a single formal charge is being filed. Currently, we are witnessing a terrifying trend in Ashkelon and Beersheba courts. Actually, it's as usual. The Ashkelon courts have shown an unprecedented agility in rejecting the appeals against the detention of Thiago and Saif. These activists taken 1,000 kilometers away near Crete are being charged with they are not being charged with trespassing or breaching a blockade. Instead, they face accusations aiding an enemy in wartime, contact with a foreign agent. This is a common security charge used to justify extended interrogation periods under the Israeli criminal procedure law, and thirdly, providing services to a terrorist organization. These accusations seem engineered to extend their attention. Under Section 46 of the Counterterrorism Law 2016, Israel could have held them up to 96 hours, 48 plus 24 plus 24. Moreover, contact with a foreign agent accusation also give leeway to the courts, extend detention up to 96 hours, but this is also prescribed in Israeli penal law, not counterterrorism law, so they're all covering both of the laws to just keep it safe from their perspective. Thiago and Said were taken before a judge on the 3rd of May, which is nearly 90 hours after their arrest. Israel is recording humanitarian aid as material support for terrorism. Under counterterrorism law, the mere intent to enter a zone controlled by a designated group is enough to trigger these high-level charges. Under Section 31 of this piece of text, the intent assumed by the prosecution serves a legal bridge to transform a humanitarian mission into kind of a felony. They have used social media, past associations and public statements to construct a profile of terrorist affiliation long before these individuals even set on the boat, even set foot on the boat. Under Israeli law, the updated evidence ordinance and emergency powers law 1979 allows a lawyer to be barred from seeing the evidence against their client. Furthermore, under the current emergency regulations, a judge can review classified files in a closed room with the representatives of Shin Bet. So it allows this. We have seen this happen this week with Thiago and Said. The court extended their detention, not because of what they did, but because of ongoing investigations into secret files and further police interrogation. One must be prepared for the psychological toll of a legal process where you cannot face your accuser or even know the specifics of the allegation if detained by Israel. In Israeli courts, bending the laws and narrowly or widely interpreting the terms in accordance with the ethnicity of the defendant are daily practices. However, they cannot quash and hide in their legal fiction is the total transparency in GSF communication and live streams. As Judge Brandon famously put it, sunlight is said to be the best of disinfectants and electric light the most efficient policeman. This process reminds me of the battle between Mirko Centovic and Dr. B in the Zweig's Royal Game novel. Most severely, be aware of the incarceration of unlawful combatants law. This is a legal purgatory that allows for indefinite detention of non-citizens without trial if they are deemed a threat to security. The detention can be extended up to 45 days, and access to lawyer can be barred up to 75 days, and with the judge approval, up to 180 days and half a year. The term unlawful combatant was introduced by the Bush administration during the era of global war and terror. The objective of employing that term is to strip the detainees of the rights granted by the Geneva Conventions, creating a third category where they are neither civilians nor prisoners of war. Unlike this law, unlike criminal trial, well, one is innocent until proven guilty. The burden of proof in administrative detention is effectively shifted. Israel may use a refusal to cooperate with them, which is a fundamental right, as an evidence of dangerousness. So I need to keep it short, and I believe its application in the future cases to GSF flotilla is unlikely because this law, when it was legislated in 2002, and recently it got, after the 7th of October, it got updated, and these severe timelines just introduced. It was not that severe, like 3 years ago. So it is highly unlikely that it will be applied to GSF's flotilla, and they have some of the plan for, and they are, I think the draft is on the Knesset right now. At first sight, Israel's laws governing detention may appear to limit the power and authority of security. You know, they're talking about the timelines and the time spans that they have to comply with. However, there is always an Achilles heel embedded in those texts not to deprive the Chief of General Staff or Shin Bet of having a free ride at their will. In my research through counterterrorism law, Evidence Ordinance 5371, or panel law, or incarceration of unlawful competence law, as a lawyer I saw a certain pattern that the subordinate conjunction, unless, quote-unquote, does not only divide the adverbial clause and main clause, as in English grammar, but presents an open buffet for motivated reasoning. So if they call you an uncombatant, like a security threat to state, that you are, because it doesn't define, there is no textual determinacy. Like security threat is something what the Chief of General Staff calls security threat to state security. However, as such as the requirements of paying a threat to the security of the state are at the complete discretion of the Chief of General Staff, while the right to issue an incarceration order is in the quiver of high army ranks. These texts and practices constitute also great breaches of international law, the ICCPR, many times cited today, the Vienna Convention on Consular Relations, and the Fourth Geneva Convention. Under the ICCPR, which Israel has ratified, Article 9 guarantees the fundamental right to liberty and security of persons, strictly prohibiting arbitrary arrest or detention. It mandates that any individual deprived of their liberty must be informed of the reasons, brought promptly before a judge, and provided with a lawful mechanism to challenge the legality of their detention. Regarding the Vienna Convention on Consular Relations, and I don't want to get into that because the international media coverage and the awareness raised globally, I think, met the aims and objectives that is sought by Vienna Convention on Consular Relations, which is right to communicate with the consul of the home state of the detainee. However, we must be clear that the black box of domestic security legislation does not exist in a vacuum. These proceedings are subject to Fourth Geneva Convention, like the unlawful competence law. By subjecting our comrades to sleep deprivation and 24 hours light exposure, the state is in direct and textbook violation of Article 22 which strictly prohibits any measure causing physical or mental suffering to protected persons when Israel denies defense access to the secret files that justify these detentions. They strip away the right to a meaningful defense guaranteed under Article 72. The list of Israel's flagrant violations of international law cannot fit in a day-long conference. As I heard from one of my seniors recently, the real task for a researcher is to find Israel's compliance with international law. Here I think there is a relevant question about whether international law can be invoked before the Israeli courts. Israel follows a modified dualist model when it comes to applying international law directly in its courts. Theoretically, the detainees can invoke customary international laws before the Israeli courts. But if the customary rule conflicts with an explicit and unambiguous Israeli domestic law, Israeli law prevails by their constitution. Still, they have to act with the presumption of conformity, so that when they have to avoid breach whenever it's possible. Obviously, it all applies for a court that has quality of impartiality and independence. Theoretically, there is still leeway to argue in Israeli courts that laws like the unlawful competence law are overridden by the customary protections of the Geneva Conventions and the jus cogens prohibition of arbitrary detention. But the bad news is the unlawful competent laws were introduced just after the High Court of Justice ruled the emergency law were inadmissible to detain Lebanese nationals in the early 2000s. The then Supreme Court leader, Aharon Barak, you may have heard him, advised the government to enact such a law so they could circumvent the burden of the Geneva Convention. At first, the inside and outside pressure enacting the unlawful competence law, but the Bush administration just came into Israel, the Knesset's aid, and the law passed in 2002. Tragically, in the last January, this retired Supreme Court President, Aharon Barak, criticized the current Israeli government by stating Israel was no longer a liberal democracy. Good morning. I would like to end by acknowledging the bitter fact that while international law and national law are on our side, the teeth of domestic law are at the disposal of the genocidaries. Nevertheless, each of their breach of international law leaves behind a poisonous precedent for the day when Israel can no longer operate under the shade of the hegemon's exceptionality. Thank you.
Global Sumud Flotilla, presenting Sumud against colonial gatekeeping in the flotilla and board of.
Thank you very much, everyone. My intervention is titled Sumud Against Colonial Gatekeeping, the Flotilla and Board of Peace. I'll begin with two basic legal propositions. First of all, I will begin with why Israeli naval blockade over Gaza is unlawful and why the flotilla's mission is lawful. Israeli naval blockade over Gaza is unlawful because customary international law on uncompleted sea and international humanitarian law are clear. A blockade whose purpose or effect is to starve a civilian population is prohibited. A blockade that denies objects indispensable to civilian survival is prohibited. A blockade that operates as a collective punishment is unlawful. A blockade that causes disproportionate civilian harm is unlawful. These are all stipulated in San Remo Manual, Rule 102, and Geneva Conventions. Israel's obstruction of food, medicine, fuel, medical support, and humanitarian passage must also be read alongside its duties as an occupying power and ICJ's binding orders requiring unhindered humanitarian assistance. The blockade is not a neutral security or military measure. It's a part of a broader architecture of deprivation. It is an engine of genocide. Yes, blockade is unlawful. However, even if the blockade was lawful, Israel would still not able to legally intercept or divert the flotilla vessels or its passengers. This is also by customary international law stipulated at San Remo Manual Rule 113. Second proposition is Global Sumud Flotilla's mission is lawful because it is civilian, unarmed, humanitarian. It seeks to deliver relief to protected population. It exercises freedom of navigation. UN experts described the earlier flotilla efforts, specifically Freedom Flotilla's 2024 Break the Siege mission, as a material manifestation of international support for the Palestinian struggle for freedom and self-determination, and for a recognized right to receive a humanitarian aid without interference or hindrance. This statement remains fully applicable today. Under the law of sea, the same conclusion follows. UNCLOS Article 87 recognizes freedom of navigation on the high seas. 88 and 301 require a peaceful use of the seas. Article 92 protects the exclusive jurisdiction of the flag states. Article 110 allows interference only in exceptional cases, such as piracy, slave trade, unauthorized broadcasting, and state business. Flotilla's mission falls under none of these exceptions. Therefore, it is lawful both under IHL and maritime law. The flotilla, therefore, has a right to sail. It has the right to freedom of navigation. It has a right to innocent passage, thus can use the territorial waters of any state which is en route, and finally has a right to humanitarian passage. In this manner, states doesn't only have negative responsibilities and obligations in the sense of not hindering or obstructing flotilla's mission, but also positive obligations to facilitate by providing ports and logistical support. Against this backdrop, I now turn to Board of Peace. I will make 4 arguments here. First, the Board of Peace is not a neutral humanitarian coordination mechanism. It's an architecture of colonial control. It's a very form of alien domination and subjugation mechanism against which international law allows resistance. Second, neither Board of Peace nor Security Council Resolution 2803 establishing it can lawfully condition humanitarian access on submission to a foreign-dominated administrative structure. Third argument, the Global Sumud Flotilla, and with all its partners, now the flotilla is sailing as a one body with its coordination with Unite merging with Freedom Flotilla Coalition. Global Sumud Flotilla exposes this structure because it insists that humanitarian passage doesn't require colonial permission. The fourth argument is that states must not recognize or assist or operationalize any gatekeeping regime that entrenches unlawful occupation, fragments Palestinian self-determination, or obstruct humanitarian relief. The first proposition is under the first proposition. Board of Peace presents itself as in the language of order, in the language of reconstruction and stabilization. But legal thinker must look beyond the vocabulary. He should or she should examine structure, power, and effect. What's being built around Gaza is not merely a relief mechanism. It's a legal and political technology of control. It claims authority over who may enter Gaza, who may coordinate aid, who may rebuild, who may document crimes, who may provide medical or legal support, and who may participate in Gaza's future. That's not humanitarian neutrality. That's a custodianship. This is a trust issue. The board emerged after a mass destruction, during a mass starvation, and during a genocide. After the destruction of hospitals, homes, schools, universities, water systems and civilian infrastructure, it emerged after the International Court of Justice affirming the unlawfulness of Israel's continued presence in the occupied Palestinian territory. It emerged after binding provisional measures demanding humanitarian assistance. And after all this, the answer offered to Palestinians is not one confirming with their right to self-determination, but a structure which is Board of Peace and Stability Force, which requires, this is in 2803 United Nations Security Council resolution, it requires a coordination with Israeli army, coordination with the very perpetrator who is responsible for all. It's colonial administration, not a plan for liberation. It is a supervision, not any plan for reparations. It is a reconstruction under external control. This is why Board of Peace must be confronted as a legal problem as well as a political problem. Under second proposition, Security Council resolution cannot legalize what higher norms and justice and general international law prohibits. The Security Council is, yes, powerful, but it's not a sovereign over international law. It cannot suspend the prohibition of genocide. It cannot extinguish the right to self-determination. It cannot authorize the acquisition of retention and territory by force. It cannot convert unlawful occupation into lawful administration by changing the institutional label. The hierarchy of norms matters, justice matters, and administrative or security architecture entrenches unlawful control, fragments Palestinian territorial unity, or denies Palestinian people meaningful agency over their political future, then it cannot be legitimized by procedural endorsement. Not by the language of peace, not by the language of stabilization, not by the language of humanitarian coordination, and even not under the cover of UN. The risk is the legal danger of Resolution 2803 and the Board of Peace. This is the legal danger. They risk creating a system in which humanitarian access is no longer treated as a legal obligation, but as administrative privilege. Reconstruction becomes something to be managed in a neo-colonial manner. Palestinian agency becomes something to be postponed. Independent humanitarian action, like Flotilla, becomes something to be criminalized. This danger is already being actualized. The Board of Peace, just last week, after the Flotilla's vessels and people intercepted and abducted, claimed that aid must pass through its coordinated channels. 2 minutes. It described the flotilla as a performative activism. Israel also claims the flotilla undermined the coordinated aid via Board of Peace and threatens reconstruction and issues sanctions for its donors. The United States goes further. It calls the flotilla pro-Hamas initiative and urged allies or members of the Board of Peace and allies to deny port access, docking, departure, and refueling. These are not isolated political statements. They are elements of legal strategy. First, declare the Board of Peace the exclusive humanitarian and political gate. Second, treat independent humanitarian passage as unauthorized. Third, convert unauthorized passage into security threat. Fourth, use that manufactured threat to justify port denial, interdiction, detention, sanctions, deportation, seizure, and torture. This is the new grammar of blockade. The old blockade spoke in the language of naval security. The new blockade speaks in the language of coordination, vetting, authorization, and stabilization. But the legal effect is continuous. Gaza remains controlled, Palestinians remains managed, humanitarian access remains conditional, civilian solidarity becomes suspect. I conclude with two remarks, passing the old rhetoric. The flotilla is not outside of the international law, but within. It dwells within a transformative way. For that reason, flotilla exposes Board of Peace. It exposes the claim that Gaza's problem is coordination, Gaza's problem is domination, and whereas Gaza's problem is domination and subjugation. And humanitarian passage doesn't require colonial permission. Finally, states cannot hide behind Board of Peace. Their obligations remains. The duty to prevent genocide, the duty to ensure respect for international humanitarian law remains. Duty of non-recognition remains. The duty of non-assistance remains. The duty to cooperate, to bring serious breaches to end remains. All of this goes for UN Security Council 2803 and Board of Peace. No assistance, no recognition. A state shares intelligence for interdiction may assist unlawful act. A state denies port access under political pressure may assist obstruction. Let me conclude. Gaza doesn't need a gatekeeper, it needs the end of siege. It needs unrestricted humanitarian access, it needs reconstruction led by Palestinians and funded by those responsible for destruction. It needs accountability. It needs restoration within territorial unity of Palestine. So, based on all that, for this reason, Resolution 2803, which established Board of Peace, should be submitted to the scrutiny of International Court of Justice through General Assembly request for an advisory opinion. The court should be asked whether Security Council can lawfully endorse a foreign-dominated regime that conditions humanitarian access, displaces Palestinian self-determination, fragments the occupied Palestinian territory, and shields unlawful situation through the language of peace and reconstruction. The Ultra Vires 2803 should go to ICJ advisory opinion through General Assembly, and there is no problem in terms of international law for that. After that, we can speak about, again, how to reconstruct with the full agency of Palestinians. I would like to announce here, given that from last year as GSF legal team, we filed many legal proceedings in many cases, from Ireland to South Africa, from Indonesia to Turkey. And as you know, in the previous weeks, Turkish prosecutors completed their indictment, and now we have a public case against 35 Israelis who have arrest warrants issued by Turkish courts. Today, and after the interception, we had testimonies of Global Sumud Flotilla participants and passed through all forensic medication controls, and today the same thing is being repeated in the port in Marmaris. And finally, Hint Foundation and Global Sumud Flotilla joined the forces, seeking for accountability for Israeli crimes against flotilla. And their findings and identification of suspects have been already filed in many countries. And in this week, hopefully today or tomorrow, we are going to file an arrest warrant demand in the same case for 10 Israeli soldiers member of Shayet 13th Special Naval Military Unit, and we will ask for a reference in this week. Thank you.
Thank you, Ms. Zainova, for concluding the session. And now with the session completed, we will continue with the closing session. I kindly invite to the stage steering committee members of Global Sumud Flotilla. Please welcome Susan Abdallah, Patricia Ueveno Gonzalez, Şebnem Mayet, and Hüseyin Dişli. Steering committee members of Freedom Flotilla Coalition, Anne Wright, Huweyda Araf, Fida İbrahim, and Asun. GSF Türkiye Legal Team member, Hüzeyfe Küçükaytekin. And from GSF Care Team, joining us, Juana. Please welcome the honorable members of our society here. Thank you all for coming to the stage. And after the closing ceremony, please stay here because we're going to have a conference picture together.
This is the last session, final remarks by Flotilla representatives from different coalitions. We need a mobile microphone though. Taşınabilir mikrofon var mıydı acaba?
I want to say thank you for everybody that's been here today, and to the lawyers that have made this possible for us, all the discussions, all the important arguments. And the Global Sumud Flotilla today is a symbol for global solidarity. And I want to say that we have been overwhelmed lately with the interception, with the illegal detention of Saif Okishik and Tiago Avila, two members of our steering committee for Global Sumud Flotilla. And I want to say, just before that, on Sunday, the launch from Italy, the boat sailed. That day, Global Sumud Flotilla received the Guernica Award for Peace and Reconciliation. It was awarded to the Global Sumud Flotilla for our efforts to break the siege of Gaza and to break the silence around the genocide and the complicity around the genocide. They see the Global Sumud Flotilla as the efforts from people from all around the world to be in solidarity with Palestine. We sail when the leaders of the world are not doing enough. That was the day that the boats sailed from Italy, and just after, our boats were brutally, illegally attacked in international water in an act of piracy from the state of Israel, and our people were accused of terrorism. With this, I want to say that Nelson Mandela, for over 20 years, was also accused of terrorism, only to be released and be honored for all his struggle for peace. So, together, we make the world a better place. Together, we can break the siege, break the silence, and end the occupation until a free Palestine.
Hi, my name is Fida. I'm part of the Freedom Flotilla Coalition. I'm a Palestinian Canadian. I'm also daughter and a granddaughter of Nakba survivors, 1948 Palestine. Was born into this struggle, and all my life been fighting for liberated and free Palestine. And being part of the flotilla actions, I'm always proud to be part of it because we continue to challenge the siege, we continue to break the silence, and we're ordinary people and volunteers that just stand up and use our body in direct action to break that silence and do things that our governments are not doing that they're supposed to be doing. But we're also people that can't be silent. We can't live with ourselves being silent about seeing this genocide and occupation. Our compass is Palestine, and the needle points to liberation. And that's it. Thank you.
Assalamu alaikum. Rana Hamida, granddaughter of Nakba survivors, first person from 1994 to step foot in Palestine, even though it was a prison. However, what I wanted to say is thank you for all the people that brought legal grounds in here and the legal game that this is going around. I have very little trust in legal procedures because it does work for those that have the most documented evidence. While we can see injustice happening in front of our eyes, we still need to prove it somehow. And at the same time, I acknowledge the importance of that. I acknowledge the importance, and I want to bring presence here that it is very important to work on both sides. It's very important that we have people that work on the legal political game, that they try to let us chase our tails with it over and over and over again until a whole nation is wiped out and wiped out from existence, but at the same time the importance of pairing that with missions, with activations like what we do in the Global Sumud. This is only one thing that needs to happen regularly with the civil power to be able to achieve something. It is a part of, and we need to work on both of them in alignment and regularly, continuously. So just acknowledging all of the effort that exists in here. And before I pass it, I would like to share a song because I think the power of song is very, very important. And this is not necessarily a song, but it's a Palestinian promise of return. And I see Palestine more than just a land. It is an idea, but it's also a path and a way of life. It's a way of returning to justice. It's a way of returning to truth. It's a way of returning and being side by side by people that are experiencing the reality of what life is right now. And this is by Abu Arab, and it's called apprehended. However, I'm just going to share the manual, which is the promise. And it says, يا توتة النار صبرك عالزمان انجار لا بد منعود مهما طول المشوار يابا ويا دودة الدار حلفتك برب الكون لابد منعود مهما طول المشوار يابا. Thank you.
Well, after that, I don't know much to say. I'm Asun, I'm from Spain, but I now belong to the Canadian campaign, SCDG. I'm working for Palestine Science more than 25 years ago. The only thing I want to say is we all here, I think, we are in the same page. And I'm just going to ask for unity, because with unity we are stronger to fight for Palestine, for the kids, the women, and the men. Thank you.
It's fun. I would like to invite Shabna, sitting over there. So that I don't waste your time, I would like to read very briefly a letter that I wrote. I'm a little structured like that. Dear friends, we are living through a very special moment in history. A moment in which citizens from the entire world, from Mexico to New Zealand, from Sweden, South Africa, from economic powers with all their historical privilege to oppress people with this collective memory, resisting erasure. We are all rising to show those who believe that the laws are selective, that they cannot fight against the world, against organized civil society. Today, the narrative is shifting. With actions and facts, we are getting attention from the media and the political elite. But let's be clear. The violence, the blockade, and the injustice remain the same in occupied Palestine. We reject this peace proposal and which is normalized by states complicit with a genocidal state. Let us resist apathy, weariness, and sadness. And yes, it is possible to stop an army and to change the course of politicians' actions. When we are convinced that we are on one unstoppable wave of human beings united for a cause. Let us rise in this cry for justice. Today is Gaza, tomorrow, who knows? Cuba, Venezuela, or even my beautiful Mexico are on the sides of power-hungry creatures. Who will defend us if it's not ourselves? Who will make the people in power to pay attention to our diverse humanitarian crisis? In Mexico, more than 132,000 disappeared people are currently looking for justice. Let's be louder than the violence and the oppression. Palestine gave us that power. Pizan called it the Gaza effect. This invisible force that transforms the social paradigm of what we are accept or reject globally. We can't let them down, because indeed we are letting ourselves down. Let us then demand for the rebellion actors that Palestine have unconditional access to its own territory to meet the needs of its long-suffering population, that they are able to determine their own reconstruction processes and their own processes for seeking justice. and that the impunity enjoyed for decades by those who seek to harm them comes finally to an end. Let us work united for Palestine, for Gaza, until the victory forever.
My name is Ann Wright. I'm with the Freedom Flotilla Coalition, and we have 5 little ships that are ready to join up to sail to Gaza. We've been sailing to Gaza for, 2008, the very first boats that got into Gaza, and then from 2010 now to 2026. So always with the people of Palestine, the people of Gaza, the West Bank, southern Lebanon, Iran, every place the Israelis are going after people, we stand against them. Thank you.
Thank you everybody. My name is Maria Elena, I come from Italy, I am the Global Sumud Flotilla, but as Anne was saying, I was there in 2008, in the first flotilla, because yes, the siege is not on Gaza since 2023, but since 2007. It's almost 20 years that Gaza is suffering from an illegal siege, from a collective punishment, from an ethnic cleansing that everybody is aware about. But it seems that the governments, it seems that the institutions just decided to not see what is happening in Gaza and what is happening in Palestine, what has been happening in Palestine for almost a century now. So here we are talking about civilian resistance, and sometimes the word resistance is linked in our mind to something that is military, is armed, is weaponized. But this is not true, because resistance can have many faces. And these faces here are some of them. And all the hundreds of and thousands of faces of women and men, normal ones, people who in their usual life are doctors or journalists or housewives or students or retired people, they just decided to put themselves on the line. And I want to be very clear, we are not going sailing to save Palestinian people. Palestinian people don't need us to be saved, because they could teach us how to save ourselves, and we need it very much, very, very much. What we are doing is to use our privilege of white people or people who had just the luck of being born in a very happy part of the world. So there was no skill in that. We were just lucky. So we are putting our privilege at the service of the resolution of what I think it's the mother of all the injustices that we see in the world, and the heart of all what shouldn't happen in the world. So the Palestinian cause. So this is why we are sailing. This is why we will sail. This is why, and I'm going to close, the legal community should be side by side with the civil society. Because sometimes I come from Italy, and we have so many problems, but one of these problems is that sometimes the legal community has been used as a tool to punish people speaking, to punish people demonstrating, to punish people exercising their right to express themselves. So this must not happen, because we will not accept it, and because there is something that is not born with us, that it's called civil disobedience. And when a law is not fair, we have the right to disobey. Thank you very much.
Hello everyone, I am Huzeyfe, coming from Bosnia. Firstly, I want to thank WOLAS and other organizers for organizing this important international conference. As you know, our land convoy are gathering in Libya now, and our flotilla already set sail and faced inhuman intervention and interception. But as also I am an academician in the law faculty, we know that, already discussed many deficiencies of the international organization, International Criminal Court, International Court of Justice, and UN. But the problem is only not laying on these kind of institutions. As academicians, firstly, we need to discuss how in academia we are educating new generations. Maybe it is famous to all of you in this room. The most famous book of the international law is written by the person who is the lawyer of the genocide committer in front of the International Court of Justice, Malcolm Nathan Shaw. That person's textbook, which is written in the academia, as an international law, is the same person, author of that book, is also lawyer of the genocide committer. We can say that not only Palestine and Gaza is occupied, we can say that the whole world is also occupied. Therefore, this legal battle, legal front is so important, and therefore I want to thank our experts and legal workers and colleagues for organizing this important event, because the flotilla and non-convoy and their bases are coming from legal, international and local legal basis laws, and they are not against any kind of legal laws. And thank you, and hope to break siege in this way and see in the free Palestine and free world.
I'll just add to the thank yous, a special thank you to this team for putting everything together today, and to the University and WOLAS for so generously us. And there's no action when we're fighting together. I hope those that are watching at home continue doing what they're doing, and the participants, because you make this mission possible. Thank you for being here. Thank you for your courage, going through training. Yes. And one more. Thank you very much.
I would like to end the day with something very important from Gaza. And we have amongst us today a dear journalist from the northern part of Gaza. Does not understand so much English, but I'll explain to him later on. In Gaza, during the blockade, during the genocide, during the starvation, intentional starvation of Gaza, the occupation dropped flyers on the northern part of Gaza. And on the flyers, it said in Hebrew, in Arabic, in English, "We are bombing Gaza. We are killing you, and nobody cares." This was brutal, because if you are not killed of the actual bombing, you are psychologically killed. Because they want to kill the hope, they want to kill the spirit of the people in Gaza. When we gather today, when we are together, we say to Gaza, we say to the world, we are the people of the world and we care. We sail, we break the siege, we break the silence, even in the darkest moment, we have to be sure that we are on the right side of history, and inshallah, we will not stop the Palestine dream. Thank you. Okay, I'm going to say this in Arabic because we are live streaming, and if someone is watching from Gaza, I hope, I'm going to say this in Arabic. في غزة في أحدث اللحظات الحصار في القصف والتجويع المعتمد متعمد كان الاحتلال عم يرمي منشورات على شمال غزة وكان مكتوب فيها نحن نقصف قطاع غزة، نحن نقتل كل الفلسطينيين في غزة ولا أحد يبالي. لما إحنا موجودين مع بعض اليوم من كل أنحاء العالم واقفين مع بعض عم نبحر مع بعض كسر الحصار على غزة، إحنا بنحكي بصوت واحد بصوت عالي. إحنا العالم، إحنا شعوب العالم ونحن نبالي. كل الاحترام لأهلنا بغزة وكل الإصرار والعزيمة إنه إحنا ما رح نوقف، رح نضلنا نحاول حد ما نكسر الحصار، نكسر الصمت حتى تحت فلسطين. شكرا للجميع.
Hello guys, I just want to say something. I'm a survivor of genocide from Gaza, and in Gaza we are 3 years under genocide, and no one cared about us. But now, when we saw you, you give us the hope. So please never give up and keep going to break the siege and show all the world what's happening in Gaza. Thank you guys, and keep going.
Thank you so much for your powerful and emotional remarks. I want to keep you here in the stage, and I invite all of you participants to come here to the stage to take a great picture together.
End of conference picture, please.